Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound.
Order members, welcome to the 35th meeting of the Committee for Justice. The meeting is now open to the public. Members, the committee is going to be recorded and broadcast throughout Parliament buildings and online. And it's proposed that the oral evidence sessions we're due to have today from the Northern Ireland Human Rights Commission and the Department of Justice on the Police and Criminal Evidence Codes of Practice and the session with Ada Lovelace Institute on the Justice Bill be recorded by Hansard. Are members agreed?
Yep. Agreed.
Thank you. Members, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Any of us who have matters to declare with regard to interest in relation to today's business should do so now or when the particular issue arises in the meeting. Does anybody have anything they want to declare at this stage? Could I declare that I have an immediate family member who works in the legal profession?
I no longer have an immediate
You're
move
free of
now to
interest.
health, so yes, I should have noted that.
Yeah,
I need to
immediate family working in the police board.
And obviously a number of us are members of the Access to Justice APG. I don't have any apologies. And as you can see, members, we have Ciara Ferguson, Connie Egan and Doug Beattie with us online. Agenda item 2 is draft minutes. Can I ask you to turn to page 5 of your meeting pack where you'll find those minutes? Are you content that those are a true and accurate reflection of the proceedings of our meeting from last week, the 27th of March?
Yep.
Great, then I'll sign them. Matters arising, can I ask you to turn to pages 3 and 4 of your tabled papers? You'll see there's a note of the informal meeting that was held with the Minister of Justice on Monday, and that's been included in the tabled pack. This note's not intended to be a detailed summary of the discussions, but it does provide a high-level overview of the issues, and also it includes a number of suggested areas that we can follow up with the Lady Chief Justice during our informal lunch on the 29th of April. And could I ask you all to put that in your diaries, please, and make sure that you're free for that. Are members content to note that paper at this stage and to discuss the issues further with the Lady Chief Justice?
Noted, yeah.
Thank you. Yes. Just with regard to the meeting with the Lady Chief Justice, I think it may be helpful for us maybe to spend just a few moments together before we would head into that meeting. If members would be available at some stage a bit earlier on Tuesday or at some stage on Monday for that. Probably just need 20 minutes. Is that feasible for members? If we pull something together, I'd rather that we do a bit of housekeeping as we do here before we bring people in, so that we can coordinate our questions and make sure that we're covering the ground that we need to cover. Would that be all right? If we contact you with times, is that okay?
Yeah.
Yeah?
Yep.
That's great. Thanks very much. Agenda item 4 then is Police and Criminal Evidence Codes of Practice, the outcomes of the consultation on revised codes A to H and new code I, and we're about to receive oral evidence from the Northern Ireland Human Rights Commission. Members, could I ask you to turn to pages 14 to 16 and then also 17 to 610 of the meeting pack for the relevant papers. Just a reminder that we considered a written paper from the DOJ on the outcome of the consultation on amendments to PACE, the codes of practice and the new code of practice at our meeting on the 27th of February. And on that day, we agreed to request oral evidence on this matter from the Human Rights Commission and from departmental officials. So, members, today we have Colin Coffey, the Director of Policy, and Claire McCann, a Senior Policy and Research Officer from the Human Rights Commission, with us to give us their update. Folks, thank you so much for taking the time to come and speak to us today. We really appreciate it. The PACE codes are significant and large, so we're very glad to have you with us, that you can clarify some of your concerns around that. And obviously we've got the department in then after you. Please bear with me, I have the cold. So we'll hand over to you for opening statements, and then there'll be some questions for you afterwards, if that's okay. Thank you.
Thank you very much for the opportunity to present today on the revisions to the PACE Codes of Practice. As you said, I'm the Director of Policy in the Human Rights Commission, and I'm joined by Dr. Claire McCann, who's a Senior Policy and Research Officer in the Commission's Rights After Brexit team. The PACE Codes perform the vital roles of providing guidance on the powers afforded to the police to investigate crime, whilst also clarifying the safeguards necessary to ensure that the rights of individuals under investigation are respected at all times. These safeguards are particularly vital where an individual is deprived of their liberty or vulnerable. As the Department have set out, the proposed revisions and new Code I are largely generated from 3 new acts of the Westminster Parliament. I should say at the outset that whilst the Commission has a statutory role to provide advice to the Westminster Parliament, our advice was not sought during the passage of the 3 acts. In contrast, in the development of the revised codes, we're pleased to report that the Department of Justice officials reached out to us early in the development process. We were afforded an opportunity to review the proposed revisions prior to consultation, and a number of amendments were made to the revisions in line with our advice. In addition, the Department provided us with some helpful clarifications which address some of our points relating to the revisions. I understand the Department has set out our suggested revisions, and as you may have noted, these were fairly minor. We were in general content with the revisions and were particularly pleased to note the enhancement for the role of the appropriate adults. We raised some queries in relation to Code A on stop and search powers. At paragraphs 2.6 and 2.6a, Code A makes provision for the search of individuals within organised protest groups. And we note that these paragraphs have also been raised by respondents to the consultation exercise. These powers appear to be appropriately circumscribed, and the guidance notes clearly set out how decisions should be taken. Judicial determinations on legal challenges relating to searches of groups tend to focus on the particular circumstances of the case. To ensure the power to search protest groups are exercised in a proportionate and human rights compliant manner, it is important that assessments by police officers are based on sound evidence and reasoned judgment. The Commission continues to engage on a regular basis with the PSNI, and the Chief Constable's continued commitment to human rights provides important reassurance that the decision making will be appropriately guided to respect human rights. In relation to paragraph 2.6b of Code A, at our request, an additional note was provided to clarify that when considering if there are reasonable grounds for suspicion based on behaviour, a police officer should be mindful that neurodiverse individuals can inadvertently exhibit suspicious behaviour. Under Code H, relating to the detention, treatment and questions of persons under the Terrorism Act, revisions were made to ensure that persons arrested under Section 41 of the Act were adequately informed of the reasons for their arrest. And under Code I, relating to the detention, treatment and questioning by police of persons in detention under the National Security Act 2023, revisions were made to ensure that posters advertising the right to legal advice displayed in the charging area were provided in English and in the main minority ethnic languages. The Department also clarified that NIHRC staff and the staff of organisations within the National Preventive Mechanism would come under the definition of public officials who are to be given access to detainees with their consent. In reviewing the codes, the fundamental role performed by solicitors in advising and assisting individuals held in custody and being interviewed under PACE is evident. The code in a number of parts makes reference to the duty solicitor scheme. This scheme performs the important role of ensuring that those held in custody are able to promptly access a solicitor of their choosing. The Commission will continue to liaise with the Law Society to ensure that this scheme operates effectively. The Commission also highlighted the need to update how specific EU measures are referred to within the codes to take account of the new legal framework post-Brexit. We advise that we have identified both Directive 2010-64 on the right to interpretation and translation and Directive 2012-13 on the right to information in criminal proceedings as falling within the scope of the Windsor Framework Article 2, and therefore both directives set out the minimum standards below which the law in Northern Ireland cannot fall. Both these directives are mentioned in PACE Codes C, H and I. It is the Commission's view that the rights associated with criminal justice are covered by the Rights, Safeguards and Equality of Opportunity chapter of the Belfast Good Friday Agreement, due to the commitment to civil rights and the commitment to the incorporation of the European Convention on Human Rights that sits within that chapter. This appears to be in line with the reasoning of the Court of Appeal in the Dillon judgment. EU law that underpins such rights continues to set the standards which the law in Northern Ireland should not fall. We note the Information Commissioner's Office provided a response to the consultation highlighting those amendments which are relevant to its regulatory role. The PACE codes refer to relevant data protection legislation throughout. The committee members will be aware that the EU General Data Protection Regulation and Law Enforcement Directive lay down safeguards for the protection of personal data in the context of law enforcement. The Commission considers that EU data protection rules fall within the scope of the Windsor Framework Article 2. UK law currently aligns with EU minimum standards. However, if UK law were to diverge from these rules so as to reduce protections, then Northern Ireland law and practice will have to continue to align with the minimum standards in EU data protection law to avoid a diminution of rights, contrary to Windsor Framework Article 2. We welcome the Department's commitment to undertake a review of the data protection impact assessment ahead of publication of the codes. We also echo the ICO's call to ensure that both the Department and relevant enforcement agencies ensure that protection of personal data is built in by design and default when implementing changes to the PACE codes that impact on how personal data is handled and processed. In closing, there are a number of paragraphs within the codes where the language is difficult to interpret and understand without legal assistance. This is largely a consequence of the supporting acts of Parliament being legally complex. And I should say that this is not a criticism of the drafters in the Department of Justice, and I'm not suggesting any amendments to the proposed code itself. However, there are steps that could be taken to ensure the protections within the codes are more accessible and more widely understood. In England and Wales, the Home Office have developed guidance notes on rights and entitlements contained in the relevant codes, and it would be helpful if the Department could develop similar guidance notes for the PACE codes for Northern Ireland. Indeed, given the commonality between the codes, the Department could likely utilise the wording in the Home Office guidance. The Commission would of course be happy to assist the Department with this initiative. And this concludes our opening statement, and we'd be happy to answer any questions that you may have.
Very much, Colin. Okay, members. Does anybody have any questions want to follow up with the Human Rights Commission? Deirdre?
Yeah, no, thanks very much, Colin, just for coming in today. And I think obviously, we have received an appendix in terms of some of the concerns that you engaged the department on, and then we had responses under each concern or area that was raised. And I'm just wondering if you have had sight of those responses, and are you in support of all that the department are saying, or what key issues or concerns do you think are still outstanding with regards to these PACE codes?
Really, in terms of what we had raised there, the response from the department helped clarify some of our concerns and pointed us to elements in the notes that clarified. I suppose with this, there are restrictions in terms of the legislation that the codes are implementing. So there are elements where we could see potential refinements to those acts of Parliament. But in terms of the codes implementing what's provided for in the Acts of Parliament, we were broadly content with the department's response to the queries that we had raised and the suggested amendments. I think with this, overall, it comes down to the individuals who are actually going to be utilising the code and taking those decisions. So one thing that we always emphasise is the importance just of human rights considerations being built into thought processes within the police whenever it comes to exercising their powers contained within the PACE codes.
And I suppose following on, I know some of the concerns were raised and even by other people who responded to the consultation, so the whole emergence of protest groups and how they can be identified. And obviously we've seen incidents in the south of Ireland this week alone in terms of Mothers Against Genocide, in terms of the Palestinian protests and strip searches. I know they're two different jurisdictions, but that was a concern that come up. So have your concerns that you have shared around some of that, particularly in terms of identification of protest groups and then enacting some of these powers, that would be there? And then I suppose just your view, where some of these powers are enacted, particularly around stop and search, around children and young people, and just are you satisfied in terms of the departmental response, and just even in terms of the warrant versus the non-warrant around some of the powers being exercised, without a search warrant, depending on the context. Are you satisfied in terms of who makes that decision? Is the context laid out in terms of parameters that would be assessed against? Or, because these are queries that I would still have that I wouldn't have an answer to, so I'm just wondering what your views would be on those aspects.
Yeah, in relation to the protest groups and the requirements there is obviously an issue where protests impact on the rights of those, and we've seen sadly some recent incidents in Belfast where protest groups have led to violence. So there's clearly a need for the police to have powers there in relation to search and addressing those sorts of protests. The way that the decision making is set out within the code seems to us to encourage police officers to consider the rights of individuals and to be wary of the potential for, if you like, net widening or individuals being subject to searches where certain thresholds are not met. But overall, there's always the risk that a police officer wouldn't follow the procedures that are in place, and in a way, we have to have a bit of trust that what's there in those decision making will be applied in a human rights compliant manner, and a way that's considerate of the rights of all. In the context of a protest, you obviously right to freedom of expression, right to freedom of assembly, and those other considerations. So, in a way, we take some comfort in knowing the emphasis that the PSNI places on the human rights of individuals, and in terms of their thought processes. It's almost impossible to write down in a code a situation that will mean that human rights will never be abused. You could just put in place decision-making frameworks that you hope mitigate the risk of individuals ever overstepping, or put in place accountability mechanisms to ensure that any individual who does overstep is going to be addressed. And I think in terms of warrants and the general approach to the powers, I suppose a lot of this is refining pre-existing powers that are there. And we are conscious that there have been legal challenges in relation to the PACE codes, but whenever we look at the case law, it tends to be about particular circumstances where police officers have not followed what's set down in the codes as they exist at the minute, and the revisions that are proposed herein largely mirror the code as exists, but apply just in some different areas. So that provides us with some reassurance that the right basis is there.
It was just the other areas, and then I'd let others. I'm conscious not to hog it. I suppose it's just how it corresponds. I know they're separate issues in ways, but just I suppose around warrants, and I know one of the concerns come up as part of consultation was around press freedom, and just concerns around obviously even the investigatory powers tribunal judgment that was made in terms of press. It's just how it maybe corresponds with this in terms of where they do overreach at times, and where there's potentially illegal activity that takes place by state agencies in terms of trying to disrupt press freedom. Are there concerns even coming out of the judgment of that tribunal for yourselves? And my other issue was around obviously in the CCTV and image recognition, so even the rights of solicitors and others that are obviously it's their job to be in that scenario, but where their facial recognition and that is not being fed into a wider system, so the rights of those who are there in a legal capacity to support the individual, has any concerns been raised or come to your attention in terms of those issues as well?
We haven't had specific concerns raised, but in terms of those video recordings, where you're capturing the data and the image of someone, in a way, we rely on those broader frameworks, some that we refer to the GDPR and even some of the protections provided under the Windsor framework that set in place those protections in terms of how data should be stored and when it should and shouldn't be accessed. So, in a way, the information that's gathered through the PACE codes is then reliant upon the data collection and the data oversight systems that are in place within the police. I'm not sure if you want to add anything there, Claire.
No, I think from our perspective it is reassuring to see the ICO have also responded and have just emphasised that these data protection mechanisms are in place and are exercised at every level of decision making and where new codes are being implemented as well. So I mean the safeguards that exist for data protection are there wherever that kind of data is being collected, handled and processed, and there are quite clear safeguards in place for that. I don't think we would have concerns about them being misused at this point.
I think in relation to press freedom, the Commission is always concerned to ensure that the people are able to engage in investigative journalism and uncover abuses where they're taking place. So that's specific issue we haven't looked into in detail in terms of the tribunal case.
Yes.
But we'd be happy to take a look at that judgment. There is an amendment brought forward or discussed in the consultation report I see from the department. But I can maybe come back to you on that tribunal point in writing if that's okay.
Okay, thank you. No, I would appreciate that.
Thank you, Deirdre. Morris?
Thank you very much, and thanks very much for your presentation. Deirdre has touched upon one of the things I was worried about, in that being someone who worked in newspapers for 47 years, I've always respected the freedom of the press and their confidentiality. So how do you expect officers who do a search of a building and come across journalistic material, not necessarily with the journalist present, but find material within that search that is of a journalistic nature? How do you deal with that? Is that part of the evidence, or can that be disregarded? Or what happens, and what guidance is given to officers in a situation like that?
That would depend on whether the information was actually in relation to the identification of a crime. That might be something better to get clarification from the department on, in terms of where the parameters are within the code and what's expected of the police. But from a human rights perspective, there's journalists have press freedom and should be able to carry out their investigative work and their role in developing information of interest to the public and sharing that information freely. So that sort of overriding goal and purpose that journalists perform, and that almost public service that they perform in informing public debate and identifying issues of concern, is something that police should be mindful of whenever they encounter journalistic material, and how they consider it in the context of any investigation.
And in Code A, how does an officer demonstrate, a genuine and reasonable suspicion when stopping an individual suspected of terrorism or a terrorism activity? I'm thinking along the lines of a debate in the mainland, whereby someone's seen visibly and verbally threatening to kill or maim, and is not arrested by the police. However, someone is arrested by the police on terrorism charges for silently praying. It's very difficult. How does an officer decide what is the parameters for an arrest in a situation like that?
I think for the arrest is dependent upon whether a crime has been committed or not been committed. So if there are threats to kill individuals, that would be a criminal offence to make a threat against someone's life. So there would be a grounds on which to carry out an arrest. So I think a police officer in those circumstances would be guided by what the criminal law states and doesn't state in relation to their.
Maybe I'm being unfair. This happened in the mainland, but I do find it offensive for somebody to be arrested for silently praying. Somebody can threaten a life by a different way. Anyway, that's all, Chair, in the meantime.
Okay, thank you, Morris. Doug?
Thank you, Chair, and thank you for your presentation. Can I just ask a question? Because you challenged DOJ about intimate searches and strip searches, about ensuring that those who carry out that strip search or intimate search is of the same sex, and indeed anybody who's present, and there needs to be two others present, need to be of the same sex. Yet the PSNI's own guidance they do themselves, which states that, but then finishes off by saying, unless an officer has a gender recognition certificate. What's your thoughts on that?
In relation to the gender recognition certificates, I have a large file in front of me here, Doug. I can't pull out the exact paragraph, to be honest. But if there is a gender recognition certificate, and the law states that the gender of that individual should be identified by their gender recognition certificate, then that would be in line with the law to that would be recognised within the code.
So in other words, for example, a biological male who identifies as a female and has a gender recognition certificate could carry out an intimate search on a female. And does that go against the independent review on data statistics and research on sex and gender, where they're telling us we should not confuse gender with sex in this instance here?
From my perspective, all I could really say at this stage is with the gender recognition certificate, if that places a requirement, as I understand it does, that the gender that is listed in that certificate be the one that's identified for the individual, then legally that would be what the public authority would have to go on in terms of identifying the gender of an individual. But I would make the point that in terms of those searches and considerations, the interests of the subject of the search, the individual who's being searched, should always be considered. And if concerns are raised about a particular individual on any reasonable ground, one would think that would be considered to ensure that the search is being conducted in a way that respects the dignity and the rights of the individual who's being searched.
Yeah, and I completely agree with your last point there. I guess where I'm coming from is what you challenged them on was a very distinct question of sex, not gender, sex. What sex is allowed to carry out an intimate search, and they've said the sex must be the same as the one being searched. But now we're confusing that with gender. So I'm now slightly confused in regards to that. Your last point is absolutely right. We should always pay regards to the person getting searched, but we don't always have the ability to do that, and the police or the prison service may not always have the ability to do that. So I'm slightly more confused now in regards to your challenge of DOJ and their answer to you, where we were explicit in saying the word same sex carrying out the intimate search. Nothing to do with gender, same sex. Does that need to be changed if we're going to change how we're looking at this?
That's an issue, Doug. If you would permit me, I would maybe consult with DOJ in relation to in terms of that, because I can't identify the precise provision at the moment.
Could I ask, just while you're looking at that, could you also look at the issue of whether or not officers who are put in that position have the right, what their rights are in terms of, for example, female officers being asked to strip search biological males against their wishes, and vice versa. Because obviously there are issues along the lines of self-identification and so on too. So I just want to make sure that we're clear on these issues. So there are rights issues both ways, it seems to me, for the officers also.
Yeah. Certainly,
listen. Sorry, I was just going to say, look, I mean, it's not fair for me to keep pushing and pushing when you've given me a fair answer, but I'll just finish off by saying that it's left me confused now, and I do think somewhere along the line we need to clarify this and make sure it's explicit in the way we want to people to understand it. But listen, thank you for your answers.
You'll come back to us on that, yes?
Yeah, we'll do.
Thank you. Morris,
Just in clarification.
is this on this point, yes?
Yeah, absolutely. And what rights does the person being searched have to refuse to be searched by a female who identifies as a male, or a male who identifies as a female? What rights has a person being searched to refuse?
I suppose the search itself, and there's different contexts in which a search would be conducted. It's difficult to talk in the abstract, but operationally, I would envisage that if there's an easily resolved way in terms of the officer who conducts the search, that would be considered by the responsible officers. But I can consider that as well in the response that we.
I'd like to know what rights the person being searched has to refuse to be searched. Thank you.
That's great.
Thank you, Chair.
Thank you, Colin. Danny.
Thank you, Chair. I just wonder, would you be concerned about the lack of child-friendly custody environments in the north?
The justice infrastructure in general, in terms of child friendliness, is something that we would have concerns around and like to see updated. I think it's not the best in terms of getting the best possible evidence, and there's a number of challenges there where we think the prison estate could be updated to better support children.
As regards as strip search and then of vulnerable and then also children and young people, any concerns, or what are your concerns around the safeguards?
We would have something that needs to be closely monitored, and the thresholds in terms of when a strip search should and shouldn't be conducted of a child need to be closely monitored. There need to be a clear justification for it, and then any guidance in terms of how that should be carried out needs to be considered as to its necessity and the appropriateness of how it's being conducted, and who is present there whenever such searches are conducted. And the role of the vulnerable adults, the role of the appropriate adult, as I said, seems to be being reinforced in the revisions to the guidance. But I think that role of an appropriate adult, it's something that people probably don't quite understand what it is. It's something that probably people hope they'll never actually be an appropriate adult. And I haven't seen the Netflix drama where the role of the appropriate adult very much comes to the fore. But that preparing people for any circumstance in which they may be an appropriate adult, and making sure there's guidance there for those who find themselves being in that appropriate adult role, I think is very important, so that they're able to support the individual and to challenge where they think that something's taking place that shouldn't take place. I think is very important, and something that we should sort of take away as the next step with these PACE codes revision, that supporting those who support those in custody is something that needs to be considered.
That's what brought it to my mind when I watched that, because the way it's done as a one shot, you're a fly on the wall watching that part of it, and then you're just going, where's the best interest of the child at that particular time of it, and that's what brought it to me. But yeah. Thank you, appreciate it.
Thank you, Danny. We've covered a lot of ground in some of this. Can I ask you, just with regard to it's page 35, it's about section 610, and it's the provision for a solicitor to be removed from an interview.
Yeah, which code is that one, sir?
Let me see which one we're on.
E, isn't it, as well? Is it?
Yeah, D. No, it's not. I refuse their presence.
Is it H?
Yep, it's H. H610. So it's about the provision for a solicitor to be removed from an interview. And it says there, the notes at 6D and E provide some further discussion on conduct that would be considered unacceptable. Now, I can understand, yes, of course, the police need to be able to put questions to a suspect, and solicitors should not get in the way of that. However, the removal seems quite extreme, and I'm wondering, you felt sufficiently concerned to highlight the issue, and the department responds saying this isn't a big change and the Law Society is going to be included amongst the consultees. However, I'm just wondering about how frequently that issue may have arisen, and how, and these are also questions I will put to the department, how frequently it's arisen in the past, and how it's likely to be resolved, and what are the rights issues for the person being questioned in circumstances where their legal representation has been removed from the interview, because surely that is likely to have bearing on any trial that may be pursuant. Have I got Deirdre?
It's also in D as well, in terms of the solicitor involvement in identification, where it says that the officer then, in the process of identification, can even refuse the presence of a solicitor. So again, the same issues I would be concerned, or would want further clarity on. Is this an issue that comes up on a regular? Why would you need to change it? So it's maybe more, as you say, for the department as well. But I would be concerned then that your legal advisor, and what are the parameters for making that decision, and who can make that decision then within the police in terms of refusing either an interview or the identification process.
How is it ultimately resolved? Because a person can't be left without legal representation. So
I think the presumption is that particular individual, or that solicitor who's advising, who's asked to leave, that then an alternative solicitor would be provided, again, presumably of their choosing. That's one point where we emphasise in the opening statement about the duty solicitor scheme, where there's a rota of solicitors who are available to provide advice. I think it's very important that we have, being sort of a small jurisdiction, that we don't have in place the same rotas that there are in England and Wales, where it's much more formalised, and there's almost duty solicitors on in the holding stations all the time, ensuring that individuals are, if that circumstance did emerge, that they're able to identify an alternative solicitor and one that they feel comfortable with and that they're able to consult with before going back into the questioning is something that would be a concern. But yes, certainly we raise that because just that judgment call between a solicitor offering a robust defence for their client and supporting them in terms of the questions, and being obstructive and being asked to leave, that where's the dividing line there? And it's a hard thing probably to put down in the code, but I think it's important that solicitors are aware that that's in existence, and they have a clear line as to what is and isn't acceptable. And what we wouldn't want to occur is that a police officer is using that power to remove a solicitor who's perfectly legitimately advising and supporting their client.
Yes, I've never heard of it happen.
Yeah.
But it would be interesting to know, because I would imagine that there would be a rights issue there, because even if another solicitor is brought in, then you've been part way through an interview with one solicitor who's had a briefing and had their view of what the advice should be, and then you're essentially having to start from scratch with somebody else in the middle of an interview. And obviously pace is not, pace are not small issues, so yeah, that's also an issue. I'm glad that there are departmental officials in the room too, and we can pursue that with them. But could you maybe look at those issues and come back to us around some of that as well, please? That'll be really helpful. Thank you.
The right to the role of a solicitor whenever an individual is in custody is fundamental, and there always needs to be a solicitor on record whenever there's whenever an individual is being interviewed. But certainly we'll look into those specific provisions
and it may be to some extent moot if it's
we'll ask the Law
occurrence.
Society in terms of that too.
Well, I mean, the department has pointed out that the Law Society is going to be included in the consultee, so doubtless we'll hear from them. But I was interested in it from a rights perspective and the impact that there may be of having to change midway through, and actually the rights of, well, how is that dispute resolved?
Yeah.
And what rights are invoked there. But doubtless we'll hear from the departmental officials on those areas too. So, does anybody have anything further for the Human Rights Commission? No, all good.
At this point, no.
Colin, Claire, thank you so much. We very much appreciate your time today, and we look forward to hearing from. Oh, Ciara, sorry, Ciara, you have your hand up.
Yeah, just one other, and I know it may be for the department as well, but just in relation to Code Hitch, obviously dealing with detention and obviously the extension of detention without charging. Just kind of what's your thoughts on that? The department is basically referring us to the Home Office, but does the Commission have any thoughts on that?
I suppose in relation to extensions of any individual being in custody, there needs to be judicial oversight to authorise that. I think those protections are included in the parent legislation here. But that is something where we have been engaging on counter-terrorism powers at Westminster. We always highlight the need for judicial oversight when an individual is held in custody, and provisions in place to ensure that if any individual has concerns in relation to their well-being, that they're able to consult with a solicitor, have access to medical assistance if it's required, and inform. Being fully informed of their rights from their solicitor if those thresholds are met where individuals are detained for prolonged periods of time.
And just secondly, Colin, and I'm sorry, the Zoom did freeze, so I missed a good bit of your presentation, but in your introduction you had mentioned that yourselves were not consulted, although there's a statutory duty by Westminster. Is that common practice, or?
No, there's an ability for the Westminster government and the Westminster Parliament to request our advice. It's sadly not, we're not requested as much by Westminster government to provide our advice on pieces of legislation or legislation as it's progressing through. And I suppose we have legislation here that's been developed to apply across the UK. And some of the Northern Ireland specifics of it, we don't get as much consideration whenever they're enacted at Westminster. But that is, I suppose, an inevitability of the devolution settlement.
Okay, thank you.
Thank you. That's it now. Thank you so much. It's been really valuable to have you with us today, and we look forward to hearing from you on the other issues. So thank you very much for your time today.
That's great. Thank you.
Thank you. Appreciate it.
Thank you.
Sorry. Members, we're still in the same page arena, so pages 17 to 610, and we're moving on to agenda item 5, which is now oral evidence from the department with regard to the PACE codes. So we have with us Lynn Curran, who, as you'll know, is the head of the Policing Policy and Strategy Division at the DOJ, and Lisa Bowl, who is the head of Police PACE Policy and Legislation Branch, and we've had Lynn and Lisa with us previously. Ladies, you're very welcome. Thank you very much for taking the time today to work through the PACE codes with us. A fairly hefty piece of work, so we're glad to have you in front of us, and hopefully that should shorten some of the issues for us. I'm going to invite you to make your opening statement, and then we'll take questions after that. Is that okay?
Yes, of course.
Thanks
Thank you,
so
Chair.
much. Thank you.
I'd like to thank the committee for the opportunity to come before you today to provide briefing in relation to the PACE codes. As the Chair said, my name is Lynn Curran, and I'm head of Policing Policy and Strategy Division. I have with me today my colleague Lisa Bowl, who is the head of the PACE and Legislation team, and I'll be honest and say Lisa is the real expert in the room today, and most of your questions will be answered by Lisa rather than me. You're probably aware the codes support PACE Northern Ireland by setting out the legal framework and safeguards that police officers must follow when exercising their powers. The primary purpose of the codes is to ensure that police powers are used fairly, lawfully and consistently, balancing law enforcement with individual rights. The committee is aware that the Department of Justice is preparing revised PACE codes for publication and has completed a public consultation. The consultation asks for views on the proposed amendments to the code rather than feedback on the content of the codes that are already in existence. We had previously provided the committee with information on the outcome of the consultation and the draft revised versions of the code for your consideration. We have since forwarded papers to provide the committee with more information on the summary of changes and our engagement with the Human Rights Commission and the provision of some more detail in relation to the interest / campaign groups. In terms of our engagement with the Northern Ireland Human Rights Commission, we sought their feedback on the draft codes when we were preparing them for consultation. We also shared early drafts with the Commission, who subsequently provided us with their feedback. We considered the feedback provided and responded to the Commission on each of the issues they raised. This included advising them of the amendments we were making to the draft as a result of their feedback, but we also provided clarification on other of their suggestions which weren't adopted, which, for example, may have been already contained within the codes and potentially included the steps, for instance, required to secure legal advice by using the solicitor's rota. So we have shared that paper with the committee. We found the feedback at that early stage very beneficial, and we had a productive meeting with the Northern Ireland Human Rights Commission on the 2nd of May 2024 to discuss the way forward. As a result of this engagement, the Commission considered that as all their points had been addressed, they did not consider a separate response to the public consultation was necessary. So turning to the campaign groups, when we published the drafts for consultation, respondents were asked to give their views on the proposed changes and to provide reasons and evidence to support their answers. Our analysis of the responses considered three main areas. 1, what changes people supported or did not support. 2, what arguments were being made by respondents. And 3, what changes they were suggesting. In terms of the responses to the consultation, there were 16 individuals who had similar responses to the consultation questions. Although there were no identifiers such as a name, etc., to indicate an organised interest or campaign group, The responses were sufficiently similar that we decided to treat them as an organisation, as an organised interest or campaign group for the purposes of our analysis. We have included the points made by those respondents in the consultation report, along with our response to the points they raised. A summary of the comments has been shared with you for the committee's information. You're aware, I think, Chair, you mentioned it earlier on, about the SL1, the draft version of the statutory rule to the Justice Committee on the 27th of February. We hope that the briefing provided today will enable you to approve the SL1 in order to bring the PACE Codes of Practice into operation. And what I would also like to say, having listened to the feedback from our colleagues from the Human Rights Commission, there may be issues that you raised today that we can't answer today, but we're more than willing to come back to the committee in writing if that's appropriate. And we're also more than happy to continue to engage with our human rights colleagues and those from the Law Society and all other interested groups. So thank you very much, and I'm happy to take questions. Well, Lisa's happy to take questions.
That's great. Thank you very much, ladies. Okay, members. I'm opening the floor. Morris?
Yeah, it's been discussed time and again at this committee about concerns over monitoring and data handling. So the rapid expansion of AI, what measures are in place or will be in place to make sure there is no tampering using AI or any other electronic means to distort evidence?
I think that would be question appropriately directed to the PSNI, because obviously they would have that would be an operational matter in terms of how they handle and manage their information in their IT systems. And I know that the Chief Constable is obviously, I'm sure it's quite a concern for him in terms of their own data security and all those sorts of frameworks, and to make sure that if AI used, and I'm not sure if it is or not, I don't know that it is, but it would be for the police to put appropriate procedures in place. So I think that would be something that they would be better placed to comment on. But obviously, I'm sure that they would want to make sure that if they were using any AI in evidence or whatever, that the data protection and all the appropriate safeguards were appropriately protected to safeguard evidence.
Thanks very much. I mean, that's something that I'll probably take up to your police and board members. Thank you.
Anybody else?
No, thanks very much, Lynn and Lisa. And I suppose it's bits of clarity and then maybe more information to be provided as well, as you say, and I think that would be good. Just around the Code A, and I suppose the issue of protests and serious violence. So obviously it is that issue of just the competing rights then. So I mean, I can get on the one hand where the police need to move in certain circumstances. I know like an emerging issue is face coverings and things like that, you know, where there may be circumstances then to remove that in a protest or a counter kind of protest environment. But it's just around, I suppose, it's the need for this. So it does say in the report in terms of the potential to authorise stop and search zones, and it was just to see from your view or the engagement with the police whether that is a power that has been enacted, and I suppose it's how they would identify, you know, what kind of areas they would look at to identify a protest group or a group of individuals. I suppose, you know, because some of the concerns is that from some of the groups that the police would use this just in terms of trying to stop protest altogether, you know, and that right to protest on certain issues. So what additional safeguards would be put in place that there's not an overreach in terms of the right to protest, whilst obviously balancing that right to protect the public and, you know, doing all of that. So have there, you know, have concerns been raised? Has it been used? I mean, I'm not sure how widely, you know, this...
I think some of the issues around the police and protests can straddle a number of areas within the department, because obviously there's powers under PACE legislation around stop and search, but I think some of it also falls into that, the legislation around police and protests in the kind of public order counter-terror space, and that's not an area I'm overly fond with, because I know that there's issues there in that space around face coverings and that type of thing, so I'm not clear, I'm not certain around the legislation or the requirements in and around that, so I can't speak fully to that. But obviously within the PACE codes there has been some amendments to kind of strengthen you know, and to make sure that stop and search is carried out on the basis of facts and on evidence. But if there's particular issues around protest groups and removal of face coverings, I think we might need to come back on that in writing, because I'm just not sure over the full breadth of that sphere where it strands into the policing of protests and some of the more counter-terror
I
space.
suppose the face covering bit, I mean, it wouldn't be as, it's more the protest, you know, and we've seen incidents over the last year, certainly. And it's just making sure that there's not an overreach, because people have the right to protest.
Yeah,
Even if you don't agree with what they're protesting about, there's still that right.
Yeah, I think
So
that's
for
some of
me,
that-
it's, I mean, one of the issues, in terms of impact that some of the, you know, the groups who did respond to the consultation have raised is around the sufficient safeguards, what are in place then, and then at what level within the PSNI is that call made. You know, it shouldn't certainly be just a district commander level, you know, it would need to be, because of the implications one way or the other in terms of those broader public implications. So I would just be keen to see what the threshold is. I mean, I think face coverings is different, you know, than a broader, just if it's a peaceful protest. So it's just trying to get an understanding of that and that balance of rights, and you know where that balance is struck, I suppose, and who makes the decisions.
I think the thing is, the codes can set out the safeguards and the factors that the police should take into account in terms of the policing and protest and trying to balance those competing rights. But I think a lot of it is going to come down to operational decision making in terms of how the police structure their commands whenever they're setting up a command structure around policing a protest, and what levels of, I think there's varying levels of authorisation depending on the nature of the incident, and it will come down to it will be an operational matter for the police in terms of the balance that they strike and the issues that they weigh up. And I think that's very much for comes down to operational decision making and how they how really they operationalise what's in the codes. We can put the codes can set out the factors that have to be considered and the rights that have to be protected, but it's going to come down to decision making by police and individual officers and the factors that they weigh up in relation to each situation as it presents.
I would be quite confident that the police will have some sort of guidance that they go by in terms of the level of who makes those kind of decisions. It's obviously not something that we would be privy to because it is an operational issue.
Do they have guidance then? Could that be confirmed even in terms of, I mean, can you
We
check
can ask.
if there is, you know, a guidance procedure there that they would follow? Because I would be keen to, I mean, I can understand on the day it's an operational decision, so I get that, but it's the aftermath then. And is there, and I suppose it's before you go into that scenario as well in terms of the pre-planning. So I would be keen. The other bit, was around the Code B, and I know, I mean, I've raised it just with the Human Rights Commission, so it may be something to come back around press freedom. And I know one of the concerns raised, even in the consultation report, is obviously some believe that it should be a judge, it should be at that level in terms of authorising searches on journalists and stuff, and obviously on the back of the investigatory powers tribunal around press freedom issues and that being overstepped. It's just to see, you know, I suppose if the Human Rights Commissioner coming back, you know, with a kind of written report for us on that, is there a view of the department on these things as well? I would just be keen. You know, as do you see any crossover, correlation or concern in terms of, and at what level then should that decision be taken? You know,
I'm not sure that that's something that we can actually pass comment on today, to be quite honest.
No,
with
I
you.
don't mean today, I mean follow up, sorry.
And again, I'm not even sure whether it falls within the remit of the PS codes. As Lisa has said, you know, these are setting out the process, if you like, or the guidance that has to be utilised, or the law that has to be utilised, let's put it that way. But actually the application of that is for other people and how they interpret that.
And there is specific provision within the PACE legislation around warrants to in terms of journalistic material, and that the warrants have to be applied through the courts, and the code sets out the appropriate levels of authorisation in terms of the judicial tiers that have to approve each of those warrants. I think the issue around the investigatory powers tribunal, where you're getting into the more covert space, is different and outside of our remit in terms of PACE.
Yeah. And I think I would also say that if our colleagues in the Human Rights Commission or any of the other stakeholders have issues on it, well, of course, we're happy to engage with them again and talk anything through with them.
Was that the concern, because some of this feeds off from the national security legislation, which isn't under the, you know, the jurisdiction of this assembly, and that's the concern then, is what's the oversight in terms of managing that space of work. And I suppose that was my other question around Code D in terms of anonymity. just around in terms of national security related cases. So it's just who decides that,
Yeah.
who makes that call. Is that clear in terms of that space?
I think again the legislation on national security is reserved for it's the Home Office legislation. So, and I think I think it's the operational decision making around PSNI and what.
Do we know then who makes? Is it the PSNI then determine that it's national security, or in terms of code, how Code D is applied around anonymity?
I think if it's a national security matter, that would. I'm not quite clear what you mean.
It says within code that there's an amendment deny exempt in terms of officers given their names and stuff in national security related cases, but who determines what case is national security related and what isn't for the anonymity to apply?
Yeah, and
Who
again,
makes
I don't
that
think I could
call?
answer that question today, but I would imagine that would be a conversation probably between the Chief Constable and the Home Office, or whoever else in
It's just
Westminster.
to understand the
Yeah.
process.
And again, it's probably outside our remit here today.
Not determined on the basis of what you're arrested, so it's whether or not
Yeah.
you're arrested under
National
tact
security
or whether you're
yeah,
arrested.
so it
yes.
would be a PSNI call if
Yeah.
depending on the nature of the
Aye,
case,
so
they
if
would
it
be able
just
to
get
determine whether
clarity
it's,
on that would be good. Yeah, that
Perhaps
would be.
if the committee could set that out for us, Chair, in terms of what the ask is, we'll do our best to come back to you.
No, that's great, thank you. Deirdre, is that you done?
And then it was just a bit, sorry, yes, it was around the, where am I here? No, sorry, you can move on then if I need to come back. I'll sure I've asked enough for now. Thank you.
You can go ahead and finish, like. It's just, I didn't want to bring Dan in if you're still midway through.
It's just that issue then that we've raised, and I know you're going to come back, but if there's additional info around the solicitors being present, either at the identification process or at the interview, because that would be the concern in terms of, I mean, why there's a need to change it, or have there been issues for the code?
that's it.
I think this isn't a change, though.
It
is
hasn't
it?
changed. It's something that's always been there, and we have no record of it ever being raised as an issue.
So okay, so it's just then what happens then if the solicitor then is removed?
Well, obviously, again, it's never been raised as an issue, so I don't know that it's had to be addressed. But I'm sure that and I'm sure it would be I'm sure it would be a call that wouldn't be taken lightly to remove a solicitor given the rights implications. So I'm sure if it did come to that, I would imagine that I couldn't say for definite, but I would imagine they would make an effort to get an alternative solicitor in place, or they would try to agree to, how to resolve the situation. But it's not something that's been raised by us, and say it's not something new. It's always been there, and it hasn't been something that was raised by the Law Society. Didn't raise it in their consultation response or anything like that. So
Right. And the last one, I suppose, is just the recordings then. So any kind of data biometrics that is taken where, I mean, I can get the individual being interviewed, but again, it's the issue around solicitors' rights and stuff, if there is. I mean, so I can see the police officers' backs will be to the recordings potentially, but are there any issues or concerns that have been raised around recordings in an interview scenario for solicitors and how their rights are kind of protected?
not specifically in relation to solicitors. There was a consultation response in relation to appropriate adults being
Yes.
video recorded, but from what we were able to determine, that hasn't been raised as an issue ever previously. And I think the PSNI had also explained that it's only ever the audio recording of an interview that gets passed on in evidence.
But is any other type, so if is there visual recordings, are they retained in any way, or so not just being passed on in evidence? Is there any recordings done or retention kept that?
I don't think we can answer that
I
question.
think that would be for
that would be a
PSNI.
question
I'm
for
not sure.
PSNI.
Okay, thank you.
Sorry, it sounds like we're being unhelpful,
No,
but
no,
genuinely
it's-
we don't know the answer.
If we can get the follow up, then I would
We'll
appreciate
try our
that.
best.
Yeah, thank you.
Okay, Danny.
Thank you, Chair, and thank you. And I was just wondering what safeguards will be put in place for children and young people, and maybe just around strip searches and what are their best interests, how they've been protected.
I think the key point around strip search for children and young people is that the requirement that an appropriate adult has to be with them. So that would be to be in their attendance with them to make sure that they fully understand what's going on, and to obviously reassure and provide that kind of moral support as well. And then there's also, the code set out quite clearly the requirement to make sure people are treated with dignity and with respect in the situation when it's research to be carried out. But say the key protection there is the presence of an appropriate adult.
And see, as regard to the PACE codes and practice, could they ensure that custody environments are more child friendly?
Codes wouldn't necessarily be prescriptive on how a particular building or whatever should look. You know, that's not necessarily the role of the codes necessarily. I think, and the police have said that, you know, that it's difficult with the police estate because I don't think there's any rooms currently adapted for use for children within the estate. But I think that's probably, again, that would come down to the design of the estate and what resource police have to do that.
Right, Ollie. Ciara?
Thank you, Chair. It's just specifically in relation to the new code I, and I'm conscious it's quite similar to Code Hitch, but I'm also conscious that in the consultation, you had 16 responses, although you kind of grouped them because they were similar, totally rejected Code I. So it's just what work have you done, and could you clarify what measures have been put in place to address the concerns raised, particularly given that obviously it's retention up to 28 days, and I'm not too sure, you know, is that in keeping with human rights? So just your thoughts. I'd like to be more educated on it, please. Thank you.
I think in terms of the papers we provided to the committee, we set out some of the concerns that those sorts of responses had expressed and how we had responded to those. I think the major issue with that is that Code I is the guidance in relation to the National Security Act, and the National Security Act is Westminster legislation. We didn't have any input or any role or any say into that legislation because that was obviously a Home Office's call to make it legislation and to set out things like detention limits. So there wasn't really much that we could do in terms of the policy call on that. Our role is just to put out the PACE codes to set out the safeguards and what all should be done. So I think that's kind of our in terms of what we can do on that. We can't really do much because Westminster own the legislation, and the codes have to support what's set out in the legislation.
I just have a concern because I do think there needs to be an accountability mechanism for here in the North as well regarding any legislation. So I just think referring you to the Home Office maybe isn't applicable. I would love to have the department ourselves be more engaged and involved in it, and given recommendations. But no, thank you for that.
I can understand that frustration, but I think that's sometimes not within our gift, because Home Office ministers will proceed as they see fit and don't necessarily always engage our own department until on matters of national security. They will proceed as they determine they consider appropriate.
Is there any information, just for me, any further information, any work that you did do in relation to the 28 days? Given that it is not normal practice regarding detention?
I don't know if there was, and I know that another part of the department would have more of a lead role on the link into national security, and I don't know if they had any input into that or not. I'm not sure that they did, because I think the National Security Act was obviously 2023, so some of the policy development of work might have been done at a time when there was no minister in place. So I don't know if there was. I know that we didn't have any input into it, but I can't speak for other colleagues. We would need to check.
Is that something within the department maybe you could follow up on, because I am concerned, particularly maybe in breach of Article 5 of European Commission on Human Rights and the right to liberty, given that it's just not normal, the 28 days. So if there's any work that has previously been done, it would be really useful. They have that, so thank you.
Happy to ask that question.
Ciara. Stephen.
Just briefly, thanks, Chair, and thanks, ladies, for your presentation. Just reading some of the responses to the consultation, there was a wee bit of confusion just about the changes, with England and Wales and so on. Just, I suppose, for my benefit and others, I'm sure, could you just summarise the key differences if these changes come in between what will be here and in England and Wales?
We generally tend to keep the codes quite consistent with what's in England and Wales, because the powers and PACE in Northern Ireland and in England and Wales are broadly quite similar. So we do.
Does broadly reflect means that there's some difference still, that term? Broadly reflect, you know what I mean? I suppose I'm just keen to tap into what is that gap then, or what is that those key differences?
I think any differences would reflect any differences in Northern Ireland legislation or in the Northern Ireland structure or legal system. Substantively, they would be quite similar. I can't really speak off the top of my head to any major differences or any, great divergence. I think, we do follow quite closely the PACE codes in England and Wales.
Sorry, was the last bit?
We do follow. We keep the codes, quite
Yeah.
close to us in England and Wales.
You've been engaging closely with your counterparts then in the rest of the UK in terms
Yeah.
of drafting this and so on. Yeah.
Yeah.
Okay. No, that's okay. Thanks, Chair. At this stage, thank you.
Okay, thank you, Stephen. Ladies, just as you're following through with Deirdre's query, it would be useful if we could understand at the point at which NIHRC raised with you the issue around solicitors being removed. I presume that you gave consideration to how, if it ever arose, how it might be addressed. When you're going to respond to us on the issues that we'll write to you about, could you include that too, please? Because I think it would be important to know. I think it's an extreme circumstance. I'd be shocked if it had ever happened. But at the point at which it's raised, did the department think, well, it's not really an issue, or what was the initial response to that? It would be helpful to know. Thank you. Before you leave, it's kind of indirectly tied to this, but it's about this and the bill. So later on in today's agenda, we have the consultation about the contents of the list of qualifying offences, and obviously this will tie into PACE and all the rest of it. And something that struck me there was on the list of offences, wait till I find it, it's about public order. Now, yes. So for members, it's page 689. But essentially, the list of qualifying offences, one of them is public order, riotous assembly, unlawful assembly, and affray. And riotous assembly, clear enough. Affray, clear enough. Unlawful assembly, if that's a qualifying offence, it strikes me then people who had their DNA retained would be retained for 75 years. So essentially, if people gathered, or if a few people walked down the street without an 11-bar-1, their DNA is going to be retained for 75 years. And a whole raft of the issues that we've been considering is about whether or not the retention periods are proportionate. So I'm asking you purely because you're in front of me now, did you, and I appreciate you're not the bill team, but you're involved in it, was consideration given to this? Or, I know that this is just a consultation and you'll work through, but it strikes me that having your DNA retained for 75 years because you happened to gather, or because you happened to not submit an 11-bar-1, strikes me as disproportionate.
I can't speak off the top of my head to that particular offence. It would probably need to come back to
I
that
appreciate
one
I put you in
online.
the spotlight.
I imagine it's probably because there's been a similar offence has been on as a qualifying offence, and it's been brought on to sort of equalise the list to make sure it's all consistent. I imagine it's been something like that.
No, I cannot. It's just there are things. Rioting, yes. Affray, yes. Disorderly behaviour, all those things. But public order offences don't always involve violence or bad behaviour. So I just would be a wee bit concerned about the proportionality around that. But doubtless we'll come to it, and that's something we'll come back to. I was just checking with you while you were in front of me. So
yeah, I think it's probably because it's been considered as a sort of an ancillary offence or an equivalent historical offence, and it's been kept on for those reasons.
That's great. Yes, thank you. Let me just check. Yes. Obviously, there are a number of issues that you're going to come back to us on. Could I check with you then? Is it essential that this stuff is operational by the 1st of June? Do we have a bit of time? Can we take over Easter to kind of liaise with you further about the queries we've got? Or what way are we with time frames?
I think ideally we would like to progress them as quickly as possible, but more than happy to take the time to work through any issues the committee has. I think it would be helpful for us if you want to write and set out the particular queries we have, so that we make sure that we're covering everything that you have and the specific issues, and then we can come back and write on those.
No, that's great. Thank you. Are members content with that then?
Yeah.
Yes, thank you. Ladies, thank you both very much. Really appreciate it. Nice to see you again, and doubtless we'll see you again in the future. Thank you very much. So, members, in light of what you've heard, and obviously we're going to write to the department, thank you very much. We're going to write to the department and with the additional queries that we've got and wait their response. On that basis, you can tend to defer the approval of the SL1 for now until we hear those responses.
Yeah,
Yeah,
that would be good.
That's lovely, thank you. Agenda item 7 then is the Justice Bill, and we're due to receive oral evidence from the Ada Lovelace Institute. I'd ask members to turn to page 621 to 637 of the pack. We're going to have Michael Birtwistle, who's the Associate Director of Law and Policy at the Ada Lovelace Institute, and he's going to give oral evidence to us on the bill. Predominantly the Ada Lovelace Institute is associated with biometrics, so that's the focus of our discussion today. Michael, you're very welcome to the meeting. Thank you so much for taking the time to speak to us today and give us some evidence. We're very interested in what you have to say. So I will hand over to you for some opening remarks, and then if you're content to take questions, would that be all right?
That would be great. Thank you so much, and thank you so much to the committee for having me today. Can you all hear me okay?
Yes, thank you.
Would you be happy for me to present for about 10 minutes and then I can sort of take questions? Would that work?
That's
or a little shorter?
Yes, 10 to 15 minutes is perfect. Thank you.
Perfect, lovely. Okay, I'm going to attempt to share my screen if that's helpful to present, but I may need permissions for that, and if not, I will just plow ahead. Ada Lovelace Institute is an independent research institute based in the UK and in Brussels, and our mission is to make AI and data work for people in society. So we are primarily a research organisation with a policy function that I look after. As you say, our sort of first foray into biometrics was in 2020, and we conducted a sort of synthesis report that combined a legal review by Matthew Ryder QC and a sort of wrap up of a bunch of public engagement and public attitudes work research that looked at what was called the Citizens Biometrics Council. It took 50 ordinary people through the process of learning about biometrics and understanding how they relate to them and what they would how they would want it to be governed, and a public attitude survey called Beyond Face Value as well. And we've been updating that work since, and I'm going to talk you through, I suppose, firstly, the developments that we're seeing in biometrics, at least in England, and also, I suppose, the outcomes of our recent public attitudes work to understand where people are sitting in relation to this sort of emblematic technology, both in terms of police use of technology and also in terms of artificial intelligence. So, as I said, we conducted this review in 2020, and we've made a number of recommendations suggesting that the UK government needed to pass new legislation that brought together the sort of oversight and enforcement of the rules around biometrics, because they are sort of inherently personal and invasive as a set of technologies, and those need to be obviously balanced against the potentially very beneficial use cases, and that at least in England there is no there's no single source of that regulation, and there is no sort of clear incentive structure to ensure that there are standards of accuracy, validity, and reliability in the way that they're used, and that though the sort of the deployment of those technologies takes into account the balance with fundamental rights such as the right to privacy. And we're seeing the use of biometrics develop. So just to go briefly back to this definition of what are biometrics. So the idea is that it is personal data that relates to the technical processing of physical, psychological, or behavioral characteristics of a real person. And what that means essentially is the difference between a photograph and a sort of a piece of biometric data is that you're measuring something about something, the person that is in that photograph. And the sort of the traditional, I suppose, first generation set of biometrics were largely related to things like fingerprints, things that it was sort of easy to calculate or compare a sort of unique profile of someone against something else. Around 5 years ago, we saw the rollout of facial recognition technologies that were increasingly using artificial intelligence to sort of increase their accuracy. And those really were measuring physical characteristics for this purpose of identification, which is usually in those contexts one-to-many. So you've got a photograph of someone that you've taken from a crowd, and you're saying, against this watch list, how likely is it that this person is one of the faces on this watch list? But what we've seen over the last 5 years is a sort of newer generation of biometric technologies take place, as well as the increasing rollout of those original technologies. So the policing minister in the UK spoke earlier in Westminster rather, spoke earlier this week and confirmed that the UK has bought 10 live facial recognition vans. And we've also had the confirmation that 2 of the first permanent sort of installations in Croydon, south of London, of a sort of permanent facial recognition cameras have been installed. And there is also a sort of movement to do what is called operator-initiated facial recognition, which is when either from a body cam or a smartphone, an officer will take a photo of an individual and try to identify them. And also retrospective facial recognition, which is when you run old CCTV footage and try and do the same analysis. And you're also seeing this newer generation of biometric technologies that are attempting to do something called categorization or classification, which instead of asking the question, who is this person, are asking the question, what is this person's gender or ethnicity? Are they paying attention? Do they intend to commit a crime? Are they being aggressive? Those are all real use cases that variously in both policing, in the Transport for London network, there was a trial in Willesden Green of some of those technologies, and in the private sector there are sort of use cases that are being marketed right now that are sort of seeking to sell that as a product, and this raises sort of even further sort of additional questions about sort of how these technologies are governed, whether or not they're proportionate, what their impact is going to be on privacy generally. In English law, we have the sort of R versus Bridges judgment, which came out in 2020. It's a Court of Appeal judgment. And that's really the only significant case law that we have on the lawfulness of facial recognition. But it does give us a map of all of the mandatory practices that live facial recognition used by the police might need to meet to constitute this idea of a sufficient legal framework to be lawful under data protection law, equality law, and a bunch of other law of England and Wales, like the Regulation of Investigatory Powers Act and so on. And this question of proportionality really comes into the question. It sort of sets a bunch of tests, such as the deployment needing to be strictly necessary for specific law enforcement purposes, for it to be only deployed where less intrusive measures can't achieve the same objectives, and where there is a fair balance struck between the rights of individuals and the rights of communities. And what we've seen so far is that these kind of newer use cases that I just described are not necessarily taking account of Bridges and a sort of proceeding and waiting, if you like, for forgiveness rather than permission. And that in the absence of having a sort of strong regulatory body that is able to sort of take the Bridges requirements and ensure that they're being applied in practice, we have sort of 2 effects. We have deployments that are occurring without taking into account, I suppose, or without having, I suppose, accountability for meeting those mandatory practices set out in Bridges. And we also have, I suppose, hesitation by police forces and others in deploying the technologies in ways that might actually be beneficial. So the policing minister in Westminster said in the UK, November 2024, some senior police leaders believe that the lack of specific legal framework inhibits their use of the technology and dampens willingness to innovate. We've also seen in the UK the Information Commissioner's Office, which sort of holds the pen on data protection law, and which itself contains, I suppose, lots of the relevant law on biometrics, has been enforcing. We've seen it enforced in the Serco case, where Serco leisure centres were essentially using facial recognition technology to sort of time keep people in and out of work, and where the ICO said that is disproportionate. There are easier ways that we've been using for hundreds of years to clock people in and out of work, and it's been sort of further updating its guidance around the use of biometrics data. The next thing I really wanted to talk about, so that's a sort of I suppose a legal framing of where we are and where we are in terms of the use cases. The other thing I suppose I wanted to cover is this question of public attitudes. We do a lot of public attitudes work at ADA, and sort of a conclusion we've reached through that research is that if people are sort of reluctant to share their data, or they use AI tools that aren't be seen as sort of legitimate, or if people are sort of withdraw from services, essentially the sort of the benefits of technology are lost if you don't have that sort of question of public trust. And so we've done quite a lot of work trying to understand how public trust relates to these kinds of technologies. And at a general level, people have very high expectations around the use of AI and being sort of protected from its negative impact, and they want independent regulation that has teeth. And they really value explainability, often above the idea of accuracy. People want to feel that they're in control and feel that decisions about them that have been made about them have been fair. And so I'm not sure I'm able to, I'm going to try sharing once more, but I think I'm not able to present slides. So I will flag a piece of public attitudes work that we have just published. This is the largest representative survey of UK citizens, 3,500, with people with oversampling of minoritized communities. There's a really nuanced set of, I suppose, views that the public have around facial recognition technology for policing, where I think it's around 91% of people perceive facial recognition technologies by policing as potentially beneficial, but at least 39%, and I say at least for a reason, can perceive the same technology as concerning. So people have these nuanced views where they don't just sort of feel on a single sliding scale, is it good or bad? They can sort of see it might have benefits, but they also can see that it will have that it might hold challenges. And one of the reasons that we deliberately oversampled from minoritized sort of communities is that those numbers change quite a lot when you look at those. So compared to sort of 39% of the general population that sort of expressed concern about facial recognition in policing, 57% of Black people and 52% of Asian people expressed concern. And these numbers, I understand, do not significantly change for Northern Ireland, which was included in the sample. Another really interesting point that came out of this most recent survey, which we did with the Alan Turing Institute, also based in London, was sort of attitudes towards regulation. We asked the question, what would make you feel more comfortable with AI? And in 2022-3, that was 62%, and it was the top thing that people said would make them feel more comfortable. And 2 years later, this year, it's 72%. And that 10% shift in 2 years is really quite extraordinary in terms of the normal speed of change in public attitudes towards big issues. So I'll talk a tiny bit just to finish off with some of the, I suppose, key issues that we see that we got from this sort of public attitudes work. Obviously, one of the major sort of questions around identity, bias, and discrimination. And I've got some nice quotes on the slides that I won't read out now, but I did want to highlight a piece of research that we've literally just brought out, which is called Making Good. It's on our website, and it was part of a project called Public Voices in AI. And what it did is it went to 3 locations across the UK, one of them being Belfast, and asked them about how they were sort of seeing these different technologies. And I think it's really interesting because it tells you about the significant gap between public attitudes towards public use of facial recognition technology in aggregate, which you might say is like broadly positive, although 39% on average is still a pretty significant proportion of the population that are concerned. But then if you look at, if you ask people about applications of that technology in specific social contexts, those views are much more nuanced. So what we did is we asked the Belfast participants in the Making Good research to role play FRT use by the police as PSNI and explore how those cameras should be used in public spaces. And these were majority white, local-born participants from both Catholic and Protestant backgrounds, as well as individuals from sort of more positive and tech optimist backgrounds, and asked them to establish recommendations for use. And this is research that was only published last week. And the group felt unable to implement facial recognition technology in Northern Ireland context at this time. And they cited worries about potential misuse or discrimination that might arise from its use. They cited their primary concern was, I suppose, distrust in current police oversight structures and the Ombudsman, and the history of Northern Ireland's contested governance. And the recommendations sort of focused on the need to create trustworthy accountability systems to maintain the progress made in community police relationships and resourcing the police before considering introducing technology into that fraught context. And I suppose to us, what that points out, what this case study points to, is the need for engagement and sort of slow, careful work with local publics to build confidence and ensure there's a wider system of trustworthy relationships are in place before introducing this sort of technology into policing. So hopefully that sort of gives you a bit of the UK picture, gives you a bit of Northern Ireland specific research that we've been doing. Just to wrap up, I suppose the sort of the key points that we're going to be talking about, we're releasing a report in a couple of weeks, are that the sort of the lawfulness of frontier biometric deployments is still in question, and absent having sort of a comprehensive legal framework, it's going to continue to lead to these sort of this duality of bad outcomes of either deployment without sort of proper oversight or sort of a hesitation to deploy. In the UK, we have a biometrics and surveillance camera commissioner that we almost got rid of last year in a bill, but is still being preserved, but who fundamentally can only report really on the, I suppose, the use of biometrics and their impact, but can't necessarily sort of affect how they're being used by police or by others in any really significant way. We know that the Home Office is likely to consult over 2025, in part to sort of address the challenges that the policing minister was outlining in that quote. And we're quite interested in the Scottish model, which is it's a devolved company over there, and some years ago, around 2-3 years ago, established a Scottish Biometrics Commissioner that works explicitly with police use of biometrics and has sort of far more teeth, if you like, in order to be able to issue mandatory guidance to forces, to Police Scotland rather, on their use of biometrics and answer questions around proportionality, for example, and retention and that sort of thing. Hopefully some of that was useful. Very happy to answer questions to the best of my ability. Yeah, I'm in your hands.
Michael, thanks so much. Yes, it really was useful, and it was also very helpful to hear the kind of the local context, and there'd been some survey carried out in Northern Ireland that's useful for us. It's also useful to have some understanding of the bigger picture across the UK, so that's really great, thank you. I'm going to open the floor now to questions, and the first is the Deputy Chairperson, Deirdre.
Yeah, Michael, thanks very much just for your presentation. I suppose some of the issues you raised we have been asking in the committee anyway, and I suppose for clarity from the department as well. Just on the last two bits that you touched on in terms of the research into the facial recognition that you've done with people here, did you say, is that already published? Is that on your website?
That's right, yeah.
Or can that be sent to the committee so that we could...
Absolutely can, yeah.
And then I suppose the other research then, you said it was it the oversight of use of biometric data that you're going to be publishing in a few weeks?
Yeah.
If we could get that as well, I think that would be useful once you have it published.
Yeah, we're pretty close to a sort of publishable draft, so I'd be happy to also share a sort of not quite published draft with the committee, so that they don't have to wait.
Yeah, no, that would be brilliant. Thank you. And I suppose it was just to ask you in terms of, obviously we are looking at, within the current legislation that we're scrutinising, to have a biometrics commissioner here. We had the Scottish biometrics commissioner over at the committee just over a month ago. And I suppose it was just to ask from your view if you feel that what's contained within the bill around the commissioner in terms of their independence but also their functions, do you believe that that's appropriate?
I think independence of a commissioner is very important. I think despite the lack of teeth that the England and Wales commissioner had, you had real accountability, and you had, if you read through, I'd say the last 5 publications that the Fraser Sampson, the preceding biometrics commissioner in England and Wales, was putting out, they really didn't pull any punches in terms of articulating the impact on, for example, privacy, on articulating the use cases that he was seeing of those technologies, and articulating for what was needed in sort of further policy or parliamentary response to those use cases. And he was able to do that because he was sort of independent from the Home Office and from the policing minister, and I think had a quite frank relationship with them. The Scottish model, I think it's I'm only sort of adjacently familiar with it, but my understanding is that there is sort of independence in the legislation. Something that I have been told anecdotally, so take this with a grain of salt, is that there are quite a lot of former Police Scotland staff among the current staff of the commissioner, and that I suppose that's likely to mean that the policies that the commissioner, or the advice that the commissioner may receive, might be sort of sympathetic to the work of the police. And if you want, I suppose, truly independent oversight, you would want to make sure that there is a balance in that advice, and so that independence happens not just sort of on the face of the bill, but in practice. I think if you were doing that in England and Wales, that would be less of a problem, because obviously we've got sort of a much more distributed set of forces. But yes, I think we strongly advocate for the independence of regulatory bodies, be they biometrics commissioners or be they the Information Commissioner's Office in the UK, in England. Keep doing that. And would advocate for that in any new commissioner too.
Yeah, and I suppose it's just so that we can look at it in terms of the role or reach of the commissioner. I mean, I know you've touched on the independence. Are there any other particular areas that you feel the commissioner's role should include, or powers that they should have? And if so, what would they be? And then the other issue is around, obviously, the scope of the commissioner within the bill. Do you believe then that the biometrics end of it should involve photos, or what is your view on that?
Yeah, so two big questions. In terms of, I'll take the second one first. I think there is a lot of value in the UK GDPR definition of biometrics, and I think the reason for that is it captures both the sort of popular use case, if you like, the currently most used use case for identification, and it also captures these emerging use cases where you're looking at behavior, or you're looking at sort of really what's going on inside someone's head and trying to guess that from what's going on outside. I think if you are thinking of this through a justice context, you may want to, or the sort of, the mandate that you have to think about this through is justice. You may want to consider restricting that, but you may want to consider not restricting that just to policing, but to the concept of surveillance, because there is in the UK an overlap between, I suppose, policing use cases and increasingly sort of security and surveillance use cases in the private sector. So there's been a lot of back and forth between the Information Commissioner's Office and the FaceWatch company. And there are a number of sort of, I suppose, artifacts of those regulatory interactions available on the ICO website, which I'd be happy to link the committee to, but that sort of describe this increasing desire for private sector actors to be able to use these technologies, but arguably for a policing adjacent purpose. Yeah. So that I think that hopefully addresses your question around sort of definitions and what should be captured. I don't think it's necessarily helpful to focus on a single medium like photos. I think you would the definition of the type of data as basically being something that's about measuring a person is really what you want to get at, because that lets you capture, you know, retinal stuff, facial recognition. You get gait analysis, which is about how you move. You have sort of measurements that look at where you're looking that are about attention, and you won't necessarily, if you just focus on a medium like a still image, necessarily would capture all of those different use cases. And the point is, I suppose, that all of those different use cases can be just as invasive as a photo. And the second point, or rather the first point that you made, was around what sort of powers a commissioner should have. Mm-hmm. I think for a policing context, the Scottish model is not a bad one. The sort of the purposes that we've articulated in our recommendation are things like publishing a register of public sector use cases, monitoring trends, which I think is already in your bill, and then the sort of the regulatory function being this assessment of biometric technologies on two levels. Firstly, ensuring that biometric technology meets the standards of accuracy, validity, and reliability that are appropriate for the context. You know, that is something that you can sort of have an argument about either way about where those standards should lie and what's appropriate for a policing context. But if you empower an independent regulator to think about that, and then sort of for thinking about uses in publicly accessible places by the public sector in public services, and by that sort of private sector using it for security services, for security purposes, to be able to sort of assess the proportionality based on human rights standards prior to use is what we would say.
No, thank you, Michael. It's just a point of clarity where you talked about the surveillance. Did you mention there's going to be a report or something, sorry, in terms of the private sector usage and I suppose the intersectionality between that and policing? Did you say there's a report coming out, or somebody's looked at that issue?
So we're bringing out a sort of policy explainer in about 2 weeks' time that will, I suppose, discuss a range of progress around what's been happening around biometrics, and will include coverage of those use cases. If you'd like a sort of much more in-depth report, I can recommend the Big Brother Watch report that came out, I think, last year, that went into a lot more detail about where it's being used and how it's being used. And as I said, I mean, this is not yet confirmed, so this is not yet sort of Westminster government policy, but my best understanding is that the UK government is likely to consult on police use of facial recognition at the very minimum, if not a broader consultation on, I suppose, police use of biometrics.
Well, that's useful. Thanks very much for that.
Okay, Deirdre.
Thank you.
Okay, I have Danny, do you want to come in this, or?
Yes, if that's okay.
Yes, go ahead.
Michael, thank you. And if I come at this through the lens of children's rights, and when it comes to biometrics, so they're in a more vulnerable position, I'm just wondering what your view would be on our justice bill around safeguarding children and young people.
So this is not an area I'm an expert in, or we have research on, but I did note that the clerk sort of said that this might be an area of interest for the committee. I think something it might be instructive for the committee to look at in terms of the UK context was the gangs matrix that was run by, I think, the Metropolitan Police Service in London, which I think is generally regarded as a pretty poor example of how to sort of record and store data around primarily young people, and which had an impact on the lives of the people that were put on that matrix, which ended up being for a variety of reasons. And I noted the conversation just before I joined about sort of different reasons that you might end up sort of on the police's radar or on their records. And I suppose the reality, you know, from research we've done and the reading I've done, the reality of how people end up on police records is often much messier than the theory, and yet can have this sort of long and lasting impact. And I think just as to sort of this question of retention that the committee was discussing earlier, it might be of interest to look at the Protection of Freedoms Act 2012 in the UK, which looks at biometric retention limits. And I believe that there is a sort of a limit that is for relevant offences, which are defined in the bill, which is about 3 years, and then the police can, I think, extend by another 2 by asking the Biometrics Commissioner. I think that's roughly how it works. And there is a longer limit, I think 15 years, for fingerprints collected for purposes of immigration and migration. But those are the sorts of figures that are used in England and Wales for that kind of data.
Ciara?
Thank you, Chair, and thank you, Michael. It's just following just from Danny. I was just, Michael, like to hear your views or within your research from local people on the issue of proportionality of the retention periods contained within the Justice Bill at this stage. Do you feel from the research that you have done that we are striking the right balance between protecting rights and obviously the prevention and detection of crime too? So it's just really from the research, has that been discussed, viewed from local people? Are they even really aware of the retention periods at this moment in time?
I'm not sure that. I'm afraid I'm not sure that came up in as part of our research. It was sort of much more targeted at, I suppose, the immediacy of like using and having to interact with cameras that are collecting your data in this way, rather than necessarily the sort of the whole onward process in terms of retention. So I'm afraid I can't eliminate you any further, but I will write to the committee with any sort of highlights from that report, along with linking that report of where, you know, sort of what their views on that technology, on those sorts of technologies is. I mean, I think the what that research does tell us is that I think there is a concern that the use of those technologies, which inherently involves the collection of this data, would be being deployed into a very fraught context, and people there was sort of, you know, notable concern about whether or not, you know, that would worsen the sort of the issues around sort of confidence in relationships with, for example, the police. I can't read more than that into it for you, but I'll invite you to read it, and I'll try and link off anything that seems particularly relevant.
And just secondly, just Michael, obviously you've re-emphasised the importance of probably oversight and what citizens want. They want to have trust and confidence and passing over that type of sensitive information. Just if you have any concerns, it is moving quite fast, and if you've noticed, you've mentioned regarding the deployment already of vans and permanent installations of facial recognition, etc. regarding just future technologies and how fast it's going, have you any grave concerns about that, the impact that may have as well?
Future technologies relating to biometrics. I mean, I suppose what we are seeing is a very accelerated pace of both deployments and capabilities, whether or not they are sort of accurate to the sort of level that you would need those technologies to be in order to safely deploy them in particular contexts. You are seeing Amazon vans with cameras that are trying to measure whether or not the driver is paying attention. You are seeing national railway stations deploying these cameras to theoretically both create what I think is termed situational awareness, but also to potentially offer people like appropriate advertising based on something that camera has determined about that person. There are sort of, as I said, sort of surveillance and security focused use cases that are being used that are of interest to both the police, or if you like, to public sector contexts like transport that are adjacent to the police and work closely with them, as evidenced by sort of Transport for London's piloting in Willesden Green. So it is important that the ability of our institutions to respond to those developments is capable and is fast and is sort of future-proofed. And I think you achieve that by ensuring that the remit is wide enough to catch all of those technologies in scope, and ensuring that those institutions are empowered enough to sort of respond flexibly to those. Does that answer your question?
Yes, Michael, thank you.
Thank you, Ciara Morris.
Thanks very much. Thanks for your presentation, Michael. There's a few concerns, and they're around facial recognition and gait recognition. And when a recording kicks in, if it's a live situation like a rally, a protest, a football match where there's violence breaking out, and how then it's reviewed hours, days after the event, and how can you be sure that it's accurate after the event, considering the advances of AI and other electronic sort of expansions, you know. So how do you expect that to be regulated, and how do you expect it to be regulated in such a way that individual freedoms will not be impinged?
So I think there's two questions about, I suppose, you know, there's rights at the individual level and there's rights at the group level. Like there is a net effect of deploying additional surveillance technologies on society that is really important. But I think the example you've talked about is sort of a little bit more focused on perhaps on the individual. I mean, in my view, a good outcome looks like, say, a police force wanting to use a new technology and going to a regulator, or having to go to a regulator and say, okay, here's something that does gait recognition and theoretically is telling us whether or not this person is being aggressive and allows us to deploy in real time the right people to the right place in order to respond to that. That regulator, as I said, is empowered to set the right standards of scientific validity and accuracy of that system, and essentially can tell the police the point at which their system is actually able to provide the level of accuracy necessary to ensure that those interventions are not happening wrongfully. And you know, that is, I wouldn't say a huge step away from how the Scottish Biometrics Commission, at least in terms of the Act, is set up. I don't have familiarity with the kind of like the evaluation or the work of the Scottish Commissioner since establishment, but that is sort of the sort of thing that's within their remit, and you know, it's through that process of sort of accountability and incentivization, really, of ensuring that something is safe enough for the purpose that you actually are going to be basing it on. Something I would also invite the committee to think about is sort of percentage accuracy rates. Quite often, you hear the Met Police quite often talk about the assessment they did with the National Physical Laboratory of one of their systems, and they hold that up as a sort of standard. These systems are now accurate, and sort of firstly, on their own terms, that is the assessment of a single system, and on a single version of that system on a single setting, accuracy setting, and they're saying, in these exact conditions, the system is not biased and doesn't produce inaccurate results. And that itself is what you really want is a regulator that's going, every time you bring out a new version of a system, we're going to test it to make sure that it's not broken and it's not going to lead to wrongful interventions. But even within that, I suppose the auspices of the accuracy that they're saying they have, even if you've got like a 95% accuracy rate, if you've got a 5% inaccuracy rate and you're sending out police officers based on that, in a context like they deploy it on Oxford Street in London, that is a lot of people that are actually experiencing a sort of a wrongful intervention where they're being asked by officers whether they are this person when they're definitely not. And there are also some important behavioural considerations that sort of fall out of that later down the line that are to do with the extent of certainty or reliance that the police then place on that system. And there was a famous case, again, that Big Brother Watch have covered in some detail regarding a person who was essentially taken to a police station despite, after being stopped, looking very little like the photo that the police had on record. But the fact that the system had flagged them was enough for the police to stick with that decision rather than to gainsay that of the system. So hopefully some thoughts there that are relevant to this question of like how an institution can ensure that those systems are accurate. And really a lot of it is about, sort of having to go through the watchdog first before you deploy in a context that's going to mean very serious potential consequences for an individual afterwards.
Yeah, thanks very much. Can I just one wee
Yes,
question?
go ahead, Morris.
Some of the new AI technology that's coming on board can strip away masks, scarves, hoodies, etc., using a composite CCTV coverage of a wide area where a crime has been committed. What's your thoughts on that type of technology as it evolves?
I mean, these technologies present two classes of risks. One is when it doesn't work and you're still deploying it, and the other is when it works very well. And then the question becomes about sort of questions of privacy. I think the fact of as an assembly or a parliament debating how these technologies should be governed in the context of setting up a regulator is the right way to ensure there is at least a minimum public debate about what the trade-offs are involved. What we're seeing at the UK is sort of in England and Wales is sort of the worst of all possible worlds, where you are getting you're getting this sort of deployment, this hesitant deployment, and you're waiting for case law to solve those sort of questions, often many years down the line, and often in sort of very hard and emotive cases. As to your question about sort of sort of composite imagery and being able to sort of strip away measures that people are taking to protect their privacy, I think it really goes to this question of proportionality. If you were to ask an independent regulator like the ICO, they would be saying, for what purpose have you decided to use a technology that is not only trying to identify people, but is trying to do that despite their efforts to not be identified? And they would take that into account into sort of balancing the rights of that individual with the sort of the legitimate interest or whatever basis that the police is trying to process that on. And I think if you were to ask a court of law, you would get as per Bridges, you would get a similar balancing in that. And Bridges actually sets quite a high bar for the situations in which that is going to be a sort of a proportionate and legitimate response. So the more, I suppose, sorry, I'm sort of working my way towards an answer, but I think the answer is the technology you've described has an increasing impact on privacy, and so you would expect that the calculations about the invasion of that privacy would be more extreme in that situation.
Fair enough. Just one.
Go ahead, Morris.
Final one. Give me a scenario. A bank robbery 20 years ago, there was CCTV. Well, there wouldn't be CCTV 20 years ago. Say a number of years ago, and there was good, clear CCTV coverage, and also a composite CCTV coverage. Could a potential bank robber be identified by stripping back all that information?
I mean, I suppose technically, if that person, like at a technical level, could that person be identified? Yes, if the CCTV was good quality enough, although 20-year-old CCTV would probably produce a pretty low accuracy rating. And that person would obviously have to be on a watch list. So they would have to be known to the police, and that face would need to have been run against that footage. I think our take generally on retrospective facial recognition is that it should be subject to the same sort of guidelines. In that instance, on the one hand, there's a question about everyone else's privacy rights that might be on that CCTV. But there is also, I suppose, a question that person is not necessarily going to immediately receive an intervention from a police officer because they're on the street right now and you're scanning their face. So those calculations change. What you really need is oversight to ensure that decisions in that context are made in a proportionate way, and those using these technologies, in this case the police, do have the appropriate guidance to understand where it crosses the line and where it doesn't.
Yeah, thanks very much, Chair. Thank you very much, Megan.
Thank you, Morris. No, it's really important to take these issues out, and they're massive issues in this about privacy versus public safety. So, not small issues for us. And Michael, your evidence thus far has been really helpful. If I could just take you back to issues around the Commissioner, please, if that's all right. Obviously, the Scottish Commissioner is accountable directly to the Scottish Parliament and independent. In Northern Ireland, we've got a number of I'm going to say commissioners, but there's a raft of kind of bodies that are of the department but not in it. Let me put it that way, which makes it very difficult for there to be accountability. And we appreciate there needs to be a balance struck between independence and accountability. Nevertheless, I think there always needs to be accountability to somewhere. So what's the accountability mechanism with England and Wales? And also, I note that the Scottish Commissioner has a code of practice. There is not a code of practice proposed for our Commissioner. What's the position in England and Wales, please?
Yes, so my understanding is that the England and Wales Biometrics Commissioner does report to Parliament. I think that is, I mean, a lot of regulators ultimately have reporting obligations to Parliament, while they will have a sponsor team within the civil service that they sort of relate to. Ultimately, their accountability is to Parliament, and that in England and Wales tends to, I suppose, preserve some measure of independence. We are seeing that being tested a little in England and Wales at the moment, with the government's growth agenda, but by and large, a minister will typically only be able to, for example, send strategic directions to a regulator, but will not be able to typically sort of alter their their sort of scope, their mandate, and their powers, and so on. There are some exceptions with respect to secondary legislation that the government might be able to issue, but typically that is the position. I believe the Biometrics Commissioner reports to Parliament, and that's one of the reasons that he was able to sort of, I suppose, speak so freely as to his concerns about the impact of these technologies. And I suppose my understanding on codes of practice, and I will write to the committee if I get this wrong, but codes of practice occupy a space in England and Wales where they sort of sit somewhere between secondary legislation and guidance in terms of how much force they have and how much different actors that they might apply to are obligated to sort of comply with them, and also, and quite crucially, how much force they have in a court of law. So that it will there is a difference, for example, in how easy it is to judicially review a code of practice versus which is enabled by a piece of legislation versus simply a piece of guidance that the regulator has issued. And so they are, I suppose, if you look at what civil society often asks for when thinking about the current Data Use and Access Bill, or thinking about the Online Safety Act, often the sort of the gold standard in the kind of guidance that civil society might ask government to ensure a regulator is issuing is a code of practice, rather than the sort of more informal guidance that that a commissioner might be empowered to issue from time to time. So it is a useful tool. It does make sure that everybody's clear about it, and I suppose commands a certain level of sort of respect to its addressees.
Thank you. And just going back to the accountability aspect, in both Scotland and England and Wales, then, where the commissioners are each directly accountable to the respective parliaments, what does that look like in practice? What are the pathways? I
suppose a lot of it is about information sharing and reporting and transparency. So the Biometrics Commissioner in the UK, in England and Wales, would typically issue sort of periodic reports, annual reports, and sort of special reports that he might have commissioned from academics or the research community, or indeed potentially from other actors like the police, and those reports would be laid before Parliament for discussion. And I may be wrong about this, but I believe that many regulators in the UK will often have a sort of reporting duty attached to a particular, for example, select committee in Parliament as well, which enables that committee to, I suppose, exert that accountability by drawing the commissioner or commissioners in for questioning, and ensure that the performance of the regulator can be assessed, and also the regulator itself essentially has a forum in which, a sort of significant forum in which to highlight the important issues that they're considering.
That's really helpful. Michael, thank you very much indeed. Does anybody have anything further before Michael leaves us? No? Michael, can I thank you? The evidence that you've given has been really useful, and you've pointed us to, you've highlighted additional issues for us, and you've pointed us to several pieces of research and information that I think we'll pursue, because I think it will help us to scrutinise this bill much better and to understand the future proofing and the potential implications. So Thank you so much for your time today. Presumably, should we have anything further, we would be able to contact you. Would that be all right?
Absolutely. It's been a pleasure. Thank you so much.
That's great. Thank you very much. Thanks, Michael. All the best. Bye. That was really useful, and also terrifying when you consider what.
No, I just googled the Big Brother report.
Yeah.
Definitely Big Brother.
Right, okay. Agenda item 8 then is Justice Bill written papers. Item 8.1 is the response from the department about the bill and the delegated powers following a briefing by the Examiner Statutory Rules. Members, you'll remember that our meeting on the 6th of March 2025, the committee received an oral briefing from the Examiner of Statutory Rules on the delegated powers in the Justice Bill and subsequently sought the department's views on a number of points raised. The department's response is at page 639 and 640 of the pack. Just on this one and the handling of it. So the department doesn't accept. The department is of the view that the nomenclature doesn't need to be brought before the Assembly. And it's the examiner's view that it does. I think each are clear in their understanding of what the issue is, and they take very different views on it. So it's for us to determine now how to proceed. There are a couple of options here, Kathy, aren't there?
Yeah, I think there are, Chair. I mean, the first of all, the department's response could go to the examiner for her views on what the department have come back with, or alternatively, the committee, if it wishes to, can write back to the department, providing some more of the background information as to why the examiner had recommended that it should be draft affirmative, and see what the department say in response to that.
Yes, Deirdre?
Yeah, no, I'd be keen to share the department's response with the Commissioner and see what her view is. And I suppose ultimately then, as we're considering the legislation, we, depending on the view of the committee, obviously, like, we can make changes, can't we? As part of it,
yes.
if we want to align with the Examiner of Statutory Rules or not. So it's just at what point then we'll be doing that potentially. But I think if we can get clarity from the Examiner on the back of the department's response, and then if we need to go back then to the department for further clarity.
I think we should. I think if we end up in that space, we're going to end up in a tit for tat.
Mm-hmm.
I think the issue with it is we went back to say the examiner thinks it should be affirmative or draft affirmative, can't remember which it was, and the department has come back to say, well, no, it doesn't merit this. But we didn't outline, because it's essentially legal advice that we get from the examiner. We didn't outline exactly why the examiner was saying it and what she had based that on.
Yeah.
And I'm wondering if the way to go might not be initially to go back to the department and say, well, actually, before you make your call on that, maybe you should give some consideration as to the rationale behind why exactly the examiner was saying what she was saying, and why we felt it was important that you changed your view on it.
Mm-hmm.
And then maybe go to the examiner.
Yeah, I'd be happy to do that as well, just to give them the opportunity. Yeah. Flexible on
Give
it
them
at this point. Yeah.
one final go.
Yeah. If they didn't get that background detail, then allow them the opportunity to at least consider that.
There's additional information that we can determine to share.
Yeah.
And
that we probably didn't before.
Yeah, and I mean, I can work with the examiner on it to make sure that, you know, the letter that goes to the department sets it out clearly, without actually giving the legal advice that was given to the committee. So I would be keen to actually make sure and run it past the examiner first before it goes to the department, but that's the way that we could go.
So if we do that, we're essentially getting a twofer.
Yeah. I'm happy with that.
Glad Hansard's not here. Right.
Never heard that before.
A twofer. So are members content that that's a reasonable way to proceed?
Yeah, content.
I think we need to give the department some rationale. I mean, we're asking them for their working out. It's probably reasonable for us to provide ours.
Yeah, that's right.
All right, thank you. And in so doing, obviously, then the examiner's going to see the department's response anyway. 8.2 is the department's response regarding the biometrics. Just kind of by way of background, at our meeting on the 6th of March, we received oral evidence from the Information Commissioner's Office about the biometrics provisions in the bill, and we agreed to forward the Information Commissioner's submission to the department for response to the points that were raised. And we also sought information on a number of other matters. You'll see again the department's response to that is at page 643 to 649. Are members content to note that, or do you require any further information or clarification?
It's probably for me more presentation on all of this, because obviously every week we're getting these addendums. We're asking questions, so for me it's just tracking it across to make sure we're not dropping the ball on anything. Is there a way that all of this can be presented, broken down into the different chunks? So if it's the biometric stuff, what are the list of questions we put in? What's the department's response? And then I think what is the evidence that we heard, you know, that led to those questions? So who was it from? I think it's just so that it's easier to read across around, are we satisfied
Have you seen
the
the table?
question is being answered?
Have you seen the table?
No.
Right. Go to page.
It's just making sure I'm tracking it across.
Go to page 657 on.
Right. Oh yes, here, yeah.
I mean, that's come as a result of kind of the issues that you raised in terms of tracking,
Yeah.
Deirdre, and I think that, I mean, and that's going to be updated as responses come in and as questions go out. Now, obviously there'll be a bit of a lag because we meet on a Thursday and the pack comes out on a Monday, but I think that'll be a really useful way. And now, part of the issue for me is that the department has indicated in its response that they've told us their rationale for 75, 50 and 25. I take a slightly different view.
Yeah.
I think they've told us what they looked at and you know, and the different places they looked. What they didn't tell us was how and why they landed on 75, 50 and 25.
That's right. And that's something the Human Rights Commission have said in terms of giving that rationale.
Yes. Well, a number of witnesses have said it,
Yeah.
and we've said it. I mean, that was our first question the day they first came to present. So they feel they've answered it. I don't feel it's an answer. They've given us an answer, but they haven't explained the rationale for why they landed. They've told us what they looked at. Mm-hmm. So I think that there are some issues that we do still want to pursue in some of those areas.
Chair, I think
yes,
that's just templated.
You think it's what?
Templated. That's been taken from another and rechecked. I mean, I'm not just 100% sure that some of the stuff that we're getting is actually authentic. It's just an opinion.
Sure, if I can just say that at last week's meeting the committee did agree to go back and make the very points that you've just made about that the letter has set out what was considered, but hasn't actually specified how the determination was arrived at for those particular retention periods. The table just wasn't, as you say, the turnaround was between Thursday and the pack on Monday, so the table wasn't actually updated to include that.
Yeah.
But it will be requested from the department, so we already have that to do.
And this table is going to be in our packs every week now,
Yeah.
so we can
David,
follow.
okay.
The other thing that occurs to me is the department is saying, okay, well, the PSNI is going to produce an outline business case for their IT system. It's not possible to cost that now. I don't know how the rest of you feel, but I was brought up in council, and you don't commit to things unless you know how much it's going to cost. An IT system of this scale could be significant, and we're also acutely conscious of the fact that the previous bill, because of our post-legislative scrutiny, previous issues about these systems were halted because the PSNI couldn't get the system, and there were issues around cost. Now, I think we can put to the PSNI, what's the issue? You know, where are you with this? What's going on with costs? And we'll not have that long to wait for. I think they're with us next week, aren't they?
Yep.
So I think we need to be teasing some of that out, because with the best will in the world, given what's going on with Northern Ireland's budget, I for one am not keen to put my hand up for something when I have no concept as to how much it would cost the taxpayer of Northern Ireland and whether or not that represents value for money. I'm not suggesting there's not a need for biometrics, Commissioner. I'm still hearing all the evidence around these issues, but I want to be fiscally responsible in decisions that we take, because Northern Ireland just doesn't have a lot of money. So we need to have some understanding of what we're committing to. And that's just how I feel about that. So, I mean, I don't know if other members want to comment, but I just don't feel it's sufficient to say, well, we'll get an outline business case further down the line when the bill is passed. That's what we're being told.
You know, if you only do any work in your own house, you get it costed. Simple. You need to know the cost.
That's my view too. Or have some semblance of a notion, you know, for like an IT system could be telephone numbers.
Oh, but I agree. I mean, we need as much information as possible. I know, because it was one of the first, I think it might have been the Human Rights Commission, that don't allow cost at the same time stop you from making the changes on the basis of, you know, European court judgments and stuff. But I think it's also that issue of subsequent regulations and when they're going to be made, and for me it's still that gap at the period in between, and you know, will things fall in that intervening period, and particularly then if there are cost implications and budgets, you know, if they're not in place, then are we going to create a gap potentially? So I just think, yeah, we need to keep going back to the department and asking for the information as we're moving through this.
Well, they're saying in their papers that the PSNI has set up a project board, and that project board is going to look at costings and outline business cases and so on. They're also telling us that the biometrics elements will all be implemented together in one go, and they don't anticipate that commencing until 18 months to 2 years after royal assent. But still, by that stage, I mean, I don't want us in another situation where legislation is passed and goes nowhere, it's not implemented. And I like to have some concept as to what the costings may be. And that's not to say it doesn't get done, but I think that we need to take decisions with an eye on, okay, well, what are the implications, and not including financially, is my view on that. You know, so. Right, that's where we are in terms of that. So are members content to note the responses, or okay, I've raised a couple of issues there. Does anybody else have anything that they want to raise from those, Deirdre?
I think it's just ahead of next week. We've obviously the police in next week on the bill, and I imagine we may do a follow-up on the biometric element of the bill depending on what we get. But could we ask them in terms of that working group, even just to say it's going to come up potentially as a question around who's involved, you know, when do they think they'll have an estimate cost? You know, how long is that going to be? And has the working group, is it already live? So maybe just that they're going to potentially get some questions on this next week, or we may need to do another, because it was something we raised 2 weeks ago around the PSNI is going to cover a wide range of the Justice Bill, and maybe Ryan can't answer all of those questions. But there are key ones like that, I think, that we need to maybe highlight with them in our discussions.
I think we could end up ultimately with more than one session with the PSNI.
Yeah, definitely.
But we'll do as much as we can, but I mean, there's a lot of stuff we need to get through with them, and I'm really conscious that there's going to be a lot more stuff for them to do, and we need to make sure they've got the budget to do it.
Sure, I think we have advised the PSNI of a number of issues that have been raised throughout the sessions. Cost, I know, was one of them. In terms of the more information about the working group, I'll have a look, because I can't remember exactly now everything that was sent out.
Called.
The project group, sorry, and I can alert them as well that there may be questions on that.
Right, so we're all content. Are you content to note then those papers? Thank you. 8.3 is the Children's Law Centre and police attendance at children's homes. I'd ask members to turn to page 652 of the pack. Further to last week's oral evidence session with the Children's Law Centre on the bill, they have provided us with information on police attendance at children's care homes and other facilities and environments where children reside. They've also shared a blog by Victim Support NI that endorses calls to raise the minimum age of criminal responsibility. Are members content to note those papers, or do you have any further information or clarification you would seek? Deirdre?
Sorry, just a comment, because I think I missed the session last week because I wasn't well, but just in terms of call-outs to particularly children's homes and even some of the mental health facilities, I don't know, and just reading it, it concerned me that calling the police was the first port of call, maybe rather than the last resort in some of these instances, and you might not do that if the child, for example, was within a family home. So I just had a concern and maybe a query. Maybe we can do it, when the officials are in again on this part of the bill and stuff, but it's that cross-departmental work with health and with other agencies. Because I just had a concern that, if the police are being called out as a first response on all of these incidents rather than as the last, I'm just concerned that there's maybe a wee trend of that.
Well,
particularly in those health settings.
There absolutely appears to be a trend from what we're seeing from the Children's Law Centre. I was wondering about the merits of, obviously we had a joint session with the Health Committee. I was wondering about the merits of sending this on to the Health Committee so that they can see, look, there's an issue here. It's not just a care homes thing.
Yep.
What I'm hearing is that even parents who are struggling with disciplinary issues are bringing in the police, more or less to, in their view, to give youngsters a short, sharp shock. The problem with it is that once you start the ball rolling, you can't move away from it. Yeah. And that's not what the police are there for. They're not, So yeah, I'm concerned about criminalisation for minor matters that are disciplinary issues. So it might be worth, and I think again in future as we move, I presume we'll have further joint meetings around right person, right care, and everything that transpires through that, and that we probably should keep a hold of this paper to raise these issues with the PSNI. But I think it's important at this stage that the Health Committee would be aware of some of these things. Our members agreed to that we would share that paper?
Agreed.
Thank you. And also, obviously the stats that go with it, there's a question there from the policing board, and they should be furnished with all of that, if that's all right. Right. Item 8.4 is request for further information. If members return to page 657, and that is where the team has collated a list of all our requests for information on the Justice Bill and the responses we've received to date. And as I've said, they're going to update this on a weekly basis for inclusion in the meeting pack. But bear in mind, they've work to do from a Thursday, and then the pack's issued on a Monday, so we need to give them a wee bit of breathing space around those. Item 8.5 is the round table event. Could I ask members to turn to page 6 to 10 of the tabled papers, please? We agreed at last week's meeting to consider options in Belfast as a venue for our round table event with grassroots organisations on the bill, and a revised list of venues can be found at page 8 of the table papers. But we've also found out that the Long Gallery is available on Thursday the 5th of June during our usual slot. So if we're going to have it in Belfast, maybe here is the place. And the other side, I actually think people enjoy to get a chance to come to Parliament buildings. There's an element to that. We like to go around the country, but also people enjoy coming. And if we're going to have it in Belfast, do people have strong views on this? Are you content to hold it in the Long Gallery then? Yeah.
No. Just one thing, Chair, there's only one venue in the Northwest listed. It's quite a stretch from the North Antrim coast right across.
Yes. So last week, Morris, we originally agreed that we would not have it in Belfast. We were going to try and move out. So the team had gone to cost the various options around the place, and you'll recall we had a bit of a conversation about, okay, well, where is a good place to hold it for the whole of Northern Ireland to come? And then the decision was, look, people are in committees and so on here in the morning. If we could have it here, just have it here. And that's where we came to last week in our informal discussions. And so we've kind of moved from a position of having to pay for a place to just having it here if the Lawn Gallery is free, because previously the Lawn Gallery hadn't been free on the dates we were looking at. So I understand what you're saying about the Northwest, but for people even who'd be coming from the southern region to head to the Northwest, I mean, it seemed to me if we're going to do it outside, then do it in the middle.
Aye.
But we've got Belfast now and we've got our own space. So our members can tend to move ahead with Belfast and the Lawn Gallery on the 5th of June rather than the May date.
Yeah.
Okay.
Just a committee day, isn't it? We're doing this, a committee
Yes.
meeting? Yeah,
so we're doing it as part of, yeah.
Yeah.
So it wouldn't be an additional event. Let me see.
Chair,
Yes, Ciara.
could I just give my apologies? Because I'll be in Brussels with the committee, Munster Committee, on the 5th of June.
All right, okay. Okay, Ciara, yes, we'll record that, thank you. That's a shame, but I understand it. Obviously, as chair of the Windsor Framework Committee, you need to be there. So, also members would suggested attendees for the event should include representatives from policing and community safety partnerships, family support hubs, neighbourhood renewal teams, rural partnerships and women's groups. So a list of those organisations can be found at pages 9 to 10 of table papers, and it would be envisaged that each of those groups would nominate one person to come so that we can actually manage to have proper engagement with people rather than token engagement. Are members content with that list, or...?
Wonder, Chair, sorry, around the restorative justice groups potentially, you know, in terms of that aspect of the bill? Or were we keeping this more focused on the other aspects? I can't remember, sorry.
Well, I think certainly my understanding, my intention really would have been that there, in terms of the restorative justice elements of the bill, we would invite the restorative justice practitioners to come in. Yes.
I know, it's okay, that's fine.
And give their evidence on their own specific issues. Are members content with that list? Could I ask, the Training for Women's Network is also an umbrella organisation that's Northern Ireland wide. Could I ask that if members were agreeable that they could be added to the list? Now, they may choose not to engage with the bill, but they might, and I'd rather they were given the option than exclude them.
Yeah.
Is that all right?
Uh-huh.
Thank you. So that's us sorted with that, yes?
Yep,
okay.
great.
Thank you. Item 8.6 then is legislative provision for a deep fake offence, and I would ask members to turn to pages 11 and 12 of the table papers. You'll see there's a meeting note that the Deputy Chairperson and I held a meeting with the Minister on Tuesday about this issue. So the Minister is eager to make provision for a deep fake offence in Northern Ireland. And as you'll see from the note in the table papers, should hope to seek a legislative consent motion to extend the provisions that are going through England and Wales to going through Parliament to extend them to Northern Ireland. Such are the nature of amendments and so on, and the path that bill has taken, that it's not possible to have an LCM to cover here or Scotland, and all of the issues wouldn't be covered anyway. So basically she had three options in front of her. Let me just get my notes up so that I've got this. She had, basically there were three options, but one of them included
Leave to the next
where
one.
other yes, sorry. Yeah. Move the legislation forward in the next mandate. However, the concern there was that the bill in which that would be included would not be the first bill of the mandate, so there would be a lag. Northern Ireland would be considerably lagging behind in terms of number of years behind the rest of the UK. An option is obviously to introduce an amendment in the Justice Bill consideration stage, so that's our Justice Bill that we're looking at now, or include provisions in the Victims and Witnesses Bill. But again, that has the potential to open up that bill to a much wider scope than was originally envisaged. So essentially, what I would ask you to do today is bear in mind that the Minister can make these amendments anyway, but she has come to speak to the committee in advance, and she wants our views on it. So there's a couple of things you need to know. The consultation process on the policy and subsequent drafting of the amendment, if it were to go in this bill, would mean that the committee would not have the opportunity to consider that amendment in the same way as the other amendments that the Minister intends to make at consideration stage. So everything that's just brought thus far, this one, which is kind of only starting. And she's asked for the committee's views on her proposed way forward before she consults with executive colleagues. So could I ask if members would take that to their parties, and we can have a discussion next week about it, but discuss with your parties with a view to reaching a committee view at the next meeting on the 10th of April. So essentially the conversation that you're having with your parties is whether or not your party is content for the Department of Justice to bring forward an amendment to consideration stage around deep fakes. And then once the Minister has indicated, once she gets kind of a feel for what the committee's view is, then they could move forward with a consultation exercise and so on, and we would be privy to all of that in all the usual ways. It just, obviously our call for evidence is closing tomorrow, isn't it? Closing tomorrow.
Yep.
So are members content to take that away and have the conversations with their parties so that we can look at it in more depth next week and give proper consideration to the Minister's request? Does anybody have any questions on that before you take it away? I mean, basically everything you need to know is in that paper. Okay? Thank you. Agenda item 9 is the PACE Northern Ireland Order 1989 consultation on contents of the list of qualifying offences as specified under Article 53A, and it's a written paper from the Department, and you'll find that at page 678 of the meeting pack. The Department plans to conduct a 14-week consultation on the list of qualifying offences as specified under Article 53A of the PACE Order 1989, and the papers advise the list of qualifying offences will be a key component of the new retention legislative framework provided for in the Justice Bill. It's therefore vital that the list of offences in Article 53A is as complete as possible, given its importance in ensuring a graduated approach to the retention of DNA profiles and fingerprints. A written briefing on the outcome of the consultation will be provided to the committee in due course then, just as usual, once it's closed. Are members content to note the paper and revisit when the outcome of the consultation was available, or do you have any further information that you would require at this stage?
No, content to reserve judgment until it comes back.
Consultation responses, okay, thank you. Agenda item 10 is correspondence. There's a correspondence memo and 6 items of correspondence starting at page 729 of the meeting pack. I'm going to draw your attention to one of the items, and then you'll have an opportunity to comment on the other items or anything else in which you've got a particular interest. Item 10.5 is correspondence from Sejini, and it's an executive summary and recommendations that relate to the inspection of the Police Ombudsman for Northern Ireland's investigation of abusive position, concerns and complaints, and a press release and copy of the report were emailed to all of you last week on the 26th of March. Can I have your agreement to request that the Police Ombudsman, the Department of Justice, the PSNI and the Public Prosecution Service, and that's essentially everybody who received a recommendation, would provide us with an indication as to whether or not they accept the recommendations initially? If not, why not? And if they do accept the recommendations, then to provide us with updates on the implementation of those recommendations which are relevant to their respective organisations in due course. Yeah?
Yeah.
Thank you. That's the only issue that I have. Does anybody else have anything further under the correspondence? No? Thank you. Are members content to note the other items then?
Noted.
Yeah.
Thank you. The forward work programme then is agenda item 11, and there's a proposed departmental forward work programme at page 849 of the pack, and an updated committee forward work programme at page 851. Does anybody have anything they want to raise on that?
As he may.
Yeah, could I just flag up in terms of next week? Next week is going to be a bruiser of a meeting. I mean, there's a lot in next week's agenda, so just, you know, it's not going to be an early finish, and please note that. But also we need to retain quorum. So are we content to schedule the proposed items of business from the department?
Yep.
Yeah.
Great.
And you're content with our own forward work programme, subject to any changes that we may need to make as a result of availability, etc. Yeah.
Great.
Thank you. Members, also just the Youth Assembly, they're coming in next week, and they'd requested the opportunity to take a photograph with the committee at next week's meeting. So to minimise disruption, we're going to try and get that photograph taken before the committee starts. Also, I'm conscious that the time with the PSNI is going to be very important, and there'll be a raft of issues, I imagine, to go through with them, because they feature in the entire bill, plus most of the amendments. So we haven't done it for a while. I was wondering about the possibility of starting the meeting at 1:30. I know that causes some of you difficulties, but it's kind of start earlier, finish earlier, as opposed to start as usual and finish much later.
I have quite a distance to come from upstairs to down here.
I know, Mars, it's going to be a struggle. I appreciate that. No, I am conscious that people have committees in the morning, and then you're coming straight in, and it's not much of a break, and it's difficult to kind of. That's difficult to keep going without getting a few minutes to yourself.
I make a sacrifice.
You're a legend, Morris. You're a legend. But
yeah, no, agreed.
Is that okay? 1:30. I want time for us. We need to sort out our questioning for the PSNI and do our housekeeping, and I don't want to eat into our questioning time to do that. So I would really appreciate if everybody could be here in time, because we can't actually make the arrangements unless everybody's in the room, because otherwise it just doesn't work. And also, if people want to be here for the photograph, then we want to try and get that done. So is that all right?
Yep.
Right, so that means then, let me see, we've sorted that out. Chairperson's business, there is none. Agenda item 13 is any other business. Does anybody have anything else?
Yes, I have a couple of... No, I'm joking.
Agenda item 14 is date, time and place of next meeting. So that's going to be Thursday the 10th of April, which is next week at 1:30 in this room. Thank you very much, members. Meeting adjourned.
Thank you, Chair.
Committee Room 30, sound.